Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. There's nothing like having a kid who misses the bus and the school is 40 minutes away, and then, kind of throws your whole day off. But we made it. We're here. We're here. No hair and makeup, but we're here. Good morning. How is everyone? It's Monday. Happy Monday. Happy Monday, and we're going to Dedham. We're going to Dedham, my friends, for the Zoom of Aiden Kearney, one of his many cases. So there's that. How is everybody? Did anybody listen to the Phelps podcast, the 34 Fairview podcast? Anyone? Hoping that this Zoom will come on. Hold on one second. All right, I don't want my video on. Do not put my video on. Hell to the no. But then why is this window not coming up? That's not what we want. We want this one. One second. Yeah, I have a lot of thoughts. I have a lot of thoughts on the Phelps things and stuff. I don't know. I'd have to go through my web browser to get the sound to come up, because StreamYard, it's a thing. One moment. You think I know my password and email? I mean, I know my email. All right, everyone, talk amongst yourselves for a minute. Talk amongst yourselves. Nothing's easy. I think the only way to get this is on Zoom, right? For those who know. One day, gonna get really, really good at technology, and it's gonna be so crazy. Like, you're not even gonna know how crazy it's gonna be. All right, let's get out of this one. And let's get into the web browser one. I don't want to open the app. I just want to launch it in here. Join from your browser. Yay. Okay, fine. Here we go. Oy vey. Oy vey. Love of the traveling Mary. Except I don't want my audio. So, free Billy Tibbets. Free Billy Tibbets. Well, with regard to that Phelps podcast, I think it's going to be really helpful for the defense. I have a whole show on that planned. And I was going to do it last night, and then, time got away and spent a lot. It's 8 hours of my life. I'm never getting back watching that podcast or listening to it anyway, although I put it on double speed. So there was that. I think, hey, Hockey Mama, thank you for the early morning super sticker. Let's hope I don't dump my iced coffee all over the floor, and that'll be a good start of the day. Billy Tibbets is a hockey player, or he was a hockey player. I think he was in jail. Is he bartender? Thank you so much for becoming a member. But here's what I found out about Phelps by listening to that podcast. Is that no, I'm good. I have it up. Thank you, though. It's up. I'm just waiting for the host to start the meeting. See? Waiting for host to start the meeting. What I found out about Phelps is that what he said, what had happened was his sister-in-law was murdered when she was 5 months pregnant. And then his brother died. And then he adopted his brother's 2 kids. So right away, he's coming from the position of someone exactly like John O'Keefe. And look, we all bring our personal biases into things, right? But how can he not sympathize with the O'Keefe family from that perspective? And so that gave me a whole different perspective. And he brought it up in 2 different episodes of that podcast. Yeah, right, Stephanie. I was taking notes too. I got tons of notes. I have tons of notes. And all of a sudden, it was like after episode 3, it got up to episode 3, and it was like fairly neutral, fairly both-sided. And then it took a sharp right turn. And it's insane. I mean, it's like almost like listening to the National Enquirer on tape. It's so salacious. It's just, there's nothing really, if I didn't know anything about this case, I would be listening to this podcast and going like, who are these people? Who are these people? Like Jerry Seinfeld used to say, who are these people? Who are these people? And why is he talking to all of these people who have nothing to do with this case, who are all peripherally involved somehow with very tenuous connections to the case? It's very, very odd. He's kind of like not really talking to anybody with any percipient knowledge. The only people he's talking to are people who are friends with Jennifer McCabe. It's weird. It's just weird. Right, exactly. He can feel for the O'Keefes, but he's assuming Karen's guilty. Yeah, yeah. I mean, he's just not listening to like the evidence or following the evidence, or did he even really do any of his own investigation is what I want to know. Or is he taking all of his information from these people that he's speaking to? And did he even watch the trial? Like, I'm confused about that. Did he even watch the trial? Does anybody know? Like, I don't want to talk too much about it because I have a show planned on it, but that's where I was kind of going with that. Is that it didn't come from a place of neutrality. It didn't come from a place of really wanting to know what really happened. It didn't come from a place of wanting to know whether or not there was even a car accident involved in the death or murder of Officer John O'Keefe. It's just gossipy, right? It's really weird. Yeah, Jen's friends, brothers, girlfriends, cousins, school teacher. Like, what the duck? He didn't watch the trial? Did he admit that he didn't watch the trial? What the duck? Sin City says, I think it's absolutely true that he couldn't get a hold of all the stuff he needed because Turtleboy didn't just lay it in his lap. He went off kilter and targeted Turtleboy and just botched it all. There was one point in there where he said that he gave Aiden a hard drive and wanted him to upload everything that he had on this case onto this hard drive. I'm sorry, are you kidding me? Like, yeah, why don't I just give you all of my journalistic investigative work so you don't have to do anything? It was really, really, really weird. Mm-hmm. I can't speak to that, Heather, because I don't have any information on that or any inside knowledge, but I'll tell you, the vibe that it gave me was just like, and who are all these people who just wanted to talk to him that are friends with the Alberts and McCabe's because some of them said some things about them that's going to be very, very helpful to the defense. And this guy did 100 hours of recorded interviews. When's anybody going to ask for those interviews and those outtakes? It's a lot of material there, and we know that Massachusetts doesn't recognize any sort of reporter privilege, so there's that. Nash says Phelps has many basic facts wrong, like not even close. Then this John Jackson, who's this John Jackson? The guy can make a coherent point, says nothing about the case and didn't even know Karen, not John's friend. He says he's John's friend, right? Didn't he say that they grew up together? I don't want anybody doxing anybody here. Hell no, don't do it. You will be deleted. We know my mods are great with the delete button, the block island button. I'm not falling prey to that. And I'm not covering that Hana Kobayashi story. Sorry, guys, just not doing it. I'm not getting into the weeds on that one. Some of these cases get too ugly too quickly. And I've already been dragged enough for covering Karen Reed, so not going to do it. Bridget says, if you're too lazy to watch the trial or not interested, you shouldn't have an opinion, let alone a podcast. Yes, Brandy did an amazing podcast. Exactly. Like, that's the kind of podcast that people should be listening to. My girl Brandy does her homework and she makes her charts and she does all of the research. She doesn't go talking to people who are peripherally involved, maybe somehow knew somebody or has known people for 10 years who's watching Matt McCabe make coffee for the garbage man. Running around making coffee for the garbage man and then going outside and having coffee with the garbage man once a week for 15 minutes. What kind of garbage? Do you guys have private sanitation in Canton? You private sanitation or is it paid for like through your taxes? I've lived in both kinds of places where you have private sanitation and you pay like quarterly. And when you pay quarterly, you can put your refrigerator out there. They will take anything. They will take anything. But the private, the public sanitation, not so much. But who's got 15 minutes to sit and have coffee outside with Matt McCabe? It's bizarre. Tell me what you think. If you've listened to it, no garbage man is stopping for 15 minutes. There's 3 guys who come by on my truck and they're like zip zap. They're like bing bang boom. They're like in and out. I just thought that was kind of odd. And that woman who gave that interview has kind of disappeared off of Twitter. She said some things that were like, I don't know if Jennifer McKay is going to be too happy about that. And imagine what wound up on the cutting room floor. Uh-huh. Stephanie. Yeah, just because they're so quick. I know. I can hear the truck coming, and then I'm like, oh, it's garbage day. And then I run downstairs and try and run the garbage cans out before they get here. As the insider in the house, good morning, darling. Our garbers are so fast, I don't even know they've been here. It's crazy. Shock and horror. Thanks for the 5. Phelps originally said she was innocent in a podcast he released during the time of the trial. Yeah, and it was kind of like, I kind of believed it for the first 3 episodes. Like I thought, because he said some things that were like, oh, okay, he gets it. He gets it. He gets the taillight thing. He gets the, why would she say I did it? I hit him, I hit him, I hit him if she really hit him. Like there were some things he said that made me feel like he was leaning that way. And then he took a really hard right. Thank you, Christine, for thanking me and for your super chat this morning. And Sasha, he claimed in text multiple times to Aiden that no one except Plevin from that side would speak to him. He's a liar. He clearly is incredible. Well, what I learned, and I have clips for you, is the reason that none of the Alberts and McCabe's would speak to him is because they are under an exclusive contract with another company. It wasn't because they didn't want to or they were afraid. It's because they have a contract with somebody else. Allegedly, according to one of their spokespeople. So there's that. Thank you for your super chat. All right. You guys, sometimes you say what I'm thinking. Sometimes you say what I'm thinking. And Salty Sea Glass, that's what I was thinking. I immediately wondered what's in the garbage or what was in the garbage. What did they once take away that perhaps they shouldn't have, or they saw something they shouldn't have, or Matt McCabe. I don't know, but who's having coffee with the garbage man once a week? And didn't we learn from the trial that Jennifer McCabe was the one who had to go make the coffee? And Matt got mad because Karen was yelling outside the house and he was embarrassed that the neighbors might hear. Thank you, Sasha. I think I already thanked you for that, but thank you again. What else did you Bederow's Turtleboy spoke about the so-called contract that they have and said it doesn't exist. I mean, I don't know if that's true. Who knows what's true at this point? Does anybody know anything about truth? Is there any? What is the truth? So there's three sides to every story, right? Your side, my side, and the truth. Always. Today's Boone sentencing. I have it set for 1:25 p.m. It's also the closings in the Daniel Penny case. Prayers up for Daniel Penny, my guys, my friends. Prayers up for Daniel Penny. They're not going to be televised because none of that trial was televised. The entire thing was shadow banned. Hopefully there'll be an acquittal today on Daniel Penny. For those of you who don't know. Yeah, I'm going to do that. I think I'm going to, we're going to pick up the Komorowski trial, I think, as when it starts. Today's just jury selection. That could take a couple of days. But yes, I think I'm going to live stream that or at least recap it every night. I haven't decided yet because I don't really know when it's going to start yet. Thank you, Sharon, for that. Let me know if you're interested in watching the Jamie Komorowski trial. She's the one who was driving allegedly in South Carolina 3 times over the legal limit in her car and slammed in. She was 25-mile-an-hour zone. She was doing something like 65 miles an hour and slammed into a golf cart carrying a bride and groom and others, and the bride was killed. Terrible story. And there is, a Brian Walsh hearing today as well. That's at 2:00. Depends on how far we get on Sarah Boone. I think there's going to be about 3. We could do the Brian Walsh. If they release a video, we may be able to do that not on real time, but maybe a little bit after. Good morning, Suze. Look at this. Look at this. David coming in. Matt is friends with the trash guy. They golf together. Union rules 2 15-minute breaks and 1 30. All right, good. So if they're friends and he's allowed to stop for 15 minutes and have coffee, that makes more sense than just having coffee with a random guy who takes your garbage. If they're friends, then allow it. Somebody has a goal, says young black economist. It's the same as everyone else's goal, making money. Think about it. You don't get paid usually for doing those things. So I don't know. It could be about clawing back your reputation as well. Right? Good morning, Kel. How are you? How are you doing, Kel? Kel's one of the amazing moderators here. We have amazing moderators here. Hello, Rachel. They're on wherever you get your podcasts, Spotify, Apple Podcasts. I don't know if I think they might be on YouTube, but it's audio only. It's called 34 Fairview Road. Good morning, Pilgrim Shadow, to the beautiful snow-covered Finger Lakes region of New York. You've got you've got some snow up there, huh? It's 28 degrees down here today, so winter is here. Winter. Thank you, Amy, for 2 matcha lattes and for thanking me. I appreciate you. So reputation cleansing. That's what I'm thinking. Who said that? Who said that? Hi, Jenna Rocco. I see somebody saying hi to you, but I don't see you. But if you're here, good morning. Good morning. Amy says, I'm generally a skeptical person. I've become quite paranoid from these trials. I trust no one anymore. Well, you know what? If you didn't watch the Brian Camp trial with me, please go back and watch it because it will restore your faith in Massachusetts. It will restore your faith in humanity. And it just may restore some of your faith in the judicial system because if you don't know about Brian Camp, here's the quick lowdown. Brian Camp, 23-year-old man, guy, kid, 23. I think he was 22 when this happened. Living in Hampshire County, Massachusetts, which is like Western Mass. He is living with his girlfriend, Brooke. They have 2 kids, ages 2 and 4, I believe at the time. The girls were sleeping in the next room. They were sleeping. Wakes up in the middle of the night. Brooke, his girlfriend, is screaming bloody murder. He sits up in bed. He's naked as a jaybird, and there's a giant man in his bedroom doorway. The giant man, who's about twice the size of Brian. The hearing started. Well, how come it's not on? How come the Zoom isn't in? How come the Zoom's not on? I mean, I got it up. Okay, you're telling me that it's on, but why is it not coming on Zoom? Is it somebody else broadcasting it from something that I can stream, like Canton Community TV? Did when I called the court, did they give me the wrong Zoom link? Refresh. Best. Okay, then people are saying it's not started. Claire has not started his either. Why is everyone giving me the wrong information? I could use the call-in number. Let me see if that works. I need one producer, just one. When I called the court, this is what they gave me. On, please.
Welcome to the conferencing center. At any time during this message, please enter your passcode has been confirmed. If you need technical assistance during your call,
Always need
press
technical
*0.
assistance.
After the tone, please state your name,
Please.
followed by the pound sign.
Melanie.
Thank you. There are 2 parties in conference, including you. The leader has not activated this conference.
Okay.
Please stand by until your call begins.
Okay, everyone says Glare has it on. Sue, do you have a different number than what's on the spreadsheet? All right, well, Sue, the spreadsheet's not right then, because I have the spreadsheet number and I also have the other number. So, I mean, what the duck, man? What the duck? Yeah, he's like, why would he send it to me? If he has it, he's doing it. So, Suze, I guess the spreadsheet's not right. Hang on. Okay, I'm looking at the goddamn spreadsheet and it's not the right number. Today's December 2nd, right?
Welcome to the conferencing center.
All right, well, let's try this.
We did not receive the correct number of passcode digits.
All right, thank you, Will. That was very kind of you to do that. Hang on, try something else. It's never easy. It's never ducking easy. One, 6, 1.
Your Honor. So, Your Honor, in this case, I came into this case on 10/19, Your Honor, and I immediately sent an email to Special ADA Mela saying that basically, hold on a second here, these phones have all sorts of privileged materials in them. And so I didn't have an exact clear picture of what was in them at that point. But I knew.
There was no assertion of attorney-client privilege.
Yes, and other privileges too, Your Honor.
No. There was no assertion of attorney-client privilege in October, right?
Initially, I said there was privileged material, knowing that there was source material, journalist source material. The most important thing that I was concerned about right when I came into the case, Your Honor, which was that these phones had source material given to Mr. Kearney from confidential sources, some of which were law enforcement people, about the very same investigators that had seized the phones. So that was the primary concern right at the beginning.
Preventive medicine doesn't deal with that, right? Preventive medicine deals with the attorney-client privilege. But in your initial disclosures or your initial representations, you were not representing that there was attorney-client privilege material on the phones.
Right, not on the first day or two when I got the case. I didn't know that yet.
Okay.
But I did say, hold on, there's privileged materials in these phones. And I wasn't certain exactly everything that it was. And my first concern was the source material. And there is a protocol in the court, and I'll give the court the citation. I don't have it right off the top of my head here. It's in my papers, but I'll give you the citation that a court needs to do a preliminary determination when there's journalist source materials raised. And I properly raised it. And I said that you know.
This was prior or it was before or after the issuance of the search warrant?
It was after the issuance of the search warrant.
After issuance of the search warrant. So a judge had previously authorized the seizure and search of the phones, right?
It's a little more complicated than that.
One thing I didn't have is the search warrant affidavit, and the affidavit in my review of the papers. Maybe it's in here somewhere in some previous filing, but it wasn't attached to any of the papers that I saw. So I need to get that.
All right. Couple of dates. 10/6 is when Judge O'Shea issued the warrant. 10/11 was when they were executed, and 10/13 was the dates they were searched and extracted. And we didn't know that specifically until counsel gave us the Celebrate reports, which showed that Trooper Guarino searched the phones on 10/13. And I have those, and I'm going to proffer those up as an exhibit.
This is Bradl speaking.
And Judge, the first exhibit I'd offer is my first email to ADA Mello.
All right. Do you have a pile of these exhibits? Just give them to me.
I do, sure.
Give me the 10 exhibits that you want to introduce.
Sure.
Judge Krupp.
I don't need them leaked
Sounds
out.
cranky.
Okay. You got 10 exhibits? How many exhibits you got?
Thank you. It depends how you want to do them. If you want to do, thank you.
Are these in order?
Somewhat, Your Honor. There's emails and there's
All right.
statements.
All right. So let me just see if there's any objection from prosecution to any of these.
None, Your Honor.
Okay. So just for the record, we have an email from Tim Bradl, subject Kearney, date October 19 at 3:57 p.m. We have Commonwealth representations regarding searching phones, a single page document. We have application for search warrant, single page document which has certain highlights on it. We have a screen share or a, what do you call this?
A screenshot, Your Honor.
Screenshot, thank you. Which in the middle says Windows cannot open the folder.
That may not be, that may not have to come up, Your Honor.
Then I'm sorry?
That may not come up, Your Honor. It's a.
All right, then we have a progress report of an extraction from Trooper Guarino. We have two of them, actually.
Those are 10/13, Your Honor.
All right, then we have a copy of, looks like the same email from Tim Bradl. You don't want a duplicate copy, right? All right, that's a duplicate. Then we have a email from Brian Tully to Tim Bradl dated April 27, 2024, which is a multi-page document.
Actually, Your Honor, the stapled copy is a series of emails going through December 20th. This refers to my request for a team and to cease searching, and it lays out the factual back and forth about the Commonwealth's refusal to.
This is April 27?
I have it's a packet that begins with October 19th, and the last page is a December 20th email.
I see, okay.
Yeah.
Yes.
That
We'll
lays
mark
out
these,
additional-
we'll mark these in the order I just identified them.
Sure.
Okay, as one Looks like 1 through 7.
Thank you, Your Honor. So, Your Honor, at the very beginning of this case, 1019, as soon as I was retained on this case, I asked if they would agree to the appointment of a taint team on 1019. I cited the preventive medicine case in that email. Counsel, if you ask me, clearly didn't apprehend, Counsel Mello clearly didn't apprehend anything about the case law about a taint team. He, on the same day, he said he would not agree to any third-party review. That's the second email. And he said he doesn't know how far they've gotten. And we were going to go to Stoughton Court at the time. I was going to go in there with a protective order to stop any searching and ask for the taint team in light of their refusal to cooperate, even though I cited the case. And a couple quick things about preventive medicine, Your Honor, I know you're aware of it, is it puts an affirmative duty on the Commonwealth to go to Superior Court and put before the Superior Court a protocol to protect any privileged documents. And
Which privilege?
well, that's the question, Judge.
Well, what is preventive medicine deals with attorney-client privilege, right?
Preventive medicine deals with attorney-client privilege.
Okay.
There's other privileges as well. Like I said, I'll give you the case. I just don't have it right in front of me. The case law says that when there's journalist issues, the court, the Superior Court, will do a review, a preliminary review of it.
It would be nice to have that case.
Yeah, I'll get it to you. It's in my computer, Judge. I'll get that to you. But just for purposes of my argument right now, I'll just say that that was on the table as well. He's a journalist. He has all this sort
All of that was known to the judge who issued the warrant authorizing the search of his records, right? Is it good?
It's called Get Ready With Me.
I don't know.
Kurt.
I suppose so. You know, these things are,
Thank you.
you know, it's the Onyx White language, Your Honor. The cell phone,
The honest what?
the Onyx White case.
Oh, Onyx White.
There's some language out of that applies here. And the language is that, you know, a cell phone is, you know, the file cabinet of everyone's entire life. And it's akin to, you know, issuing a search warrant for an entire city as opposed to one residence. There needs to be a focus on the overbreadth of the warrants here, Judge.
Well, that's a different motion.
Well, I don't think it's a different motion. I think it's another privilege that I wanted to bring before the court. And so that's what I was doing at the time, was saying, hold on a second, we need to deal with this taint team issue. And at some point, it was communicated.
Mello said no.
At some point,
Right.
yes, he said no on the
Okay.
19th.
Okay, and then you filed a motion for protective order or something?
I filed it in Stoughton District Court.
Okay, and what happened on that?
And then Attorney Mello came in and said, well, we're indicting the case anyway, so, and it wasn't heard in Stoughton District.
So you renewed the protective order in the Superior Court post-indictment?
So in Superior Court, Your Honor, at that point, you know, the chronology is important. In November, Your Honor, that's when Attorney Mello did an about face and said, okay, we're going to stop searching.
Okay.
And Attorney Mello made all sorts of vague, contradictory statements about what the status of the phones was. And those statements are in one of my...
So there's no contest that was abided by, the Commonwealth abided by that representation. That is to say, there was no searching after Mello said we're going to stop searching. The searching that you're talking about that obviously happened back in the October timeframe.
October 13th, Your Honor.
Right?
Correct.
Before you even asked for the taint team.
Right. We had
Okay.
no idea that happened.
Okay.
And it was never disclosed to us. In fact, it was covered up and we were lied to about it.
Okay.
And one of my exhibits, Judges, 6 quotes from the Commonwealth. And just so I'm clear here, Judge, we have no beef with Attorney Cosgrove's veracity on anything. We're talking about, you know, he was brought into this thing later, and we're not saying that he participated in any cover-ups or misrepresentations.
But Mello
But
did.
the first 4 are all blatant lies. If you look at number 1, this is the document marked Commonwealth Representations regarding searching phones. That exhibit, Your Honor, indicates number 1 at 11/28/23. Mr. Mello said, the state police and the investigators have not perused the material. It is in pristine form located on the defendant's devices. That is a complete falsehood. And we know it's a falsehood because on 10
I'll go back. I'll go back and listen to the hearing and take it in context. Okay,
Sure.
I'll look at it.
Go right ahead.
I'll look at it.
All of these are all misrepresentations.
Okay.
So they've misled us as to the state of the evidence. And they not only had the search of two of my clients' phones.
How are you prejudiced by that?
How are we
Because
prejudiced?
it's obviously there was
Yeah.
a search. The search happened.
Yep.
He needs his
You're going
devices
to get
back.
the contents of the search.
Give him his
Right?
devices
The
back.
extraction. Where's the prejudice?
The
Judge, read the
prejudice,
pa-
Judge,
read
so
the
first of
papers.
all, this is a suppression for unreasonable delay. My brother's going to talk about discovery issues and prejudice, but in terms of an unreasonable delay, Your Honor, this all goes to the reasonableness of the delay. But to answer your question, I know you always want to answer a judge's question when they ask you a question. And the answer is, the prejudice is that the whole reason the Commonwealth was doing this was to stop Mr. Kearney's reporting. That's why they didn't want to give him back anything. They wanted to get in there. Remember at the time, the FBI was investigating these people.
Mm-hmm.
They were dying to know what was in Mr. Kearney's phone about the FBI investigation of these people. Mr. Kearney was eating their lunch in the media, exposing them
Yep.
for all sorts of untoward behavior in the Karen Reed case.
That's being nice.
And they wanted to stop his reporting. They took his phones under this never before generated theory of witness intimidation. They took all of his devices, they cleaned out his house of every computer, iPad device in there, and they kept it.
And they
it was
arrested
full
him
of
at his
But
his-
you're looking for a sanction in a criminal case that would advantage your client, unrelated to what you are described as the prejudice. The prejudice is different, the inability to report. And if he was somehow hindered in his ability to report, I would have thought that you would have petitioned for the return of the phones. Why the phones are so important, I'm not sure I know. Is there an affidavit to that effect before me?
We did petition for that, Your Honor. We asked for the phones.
When was that? Where's the motion? Where will I find a motion for return of phones?
We asked for the.
Is there a motion for the return of the phones?
It's a different judge every hearing. This
I
is the
don't think we
problem.
got that far, Your Honor, because we were under the.
Okay, so now the next question, is there an affidavit describing the prejudice that you describe?
Judge, the prejudice is that a journalist
Needs
has
his
had the tools of his trade taken from him, and every single day he cannot access the tools of his trade. That's the prejudice.
If somebody takes my phone, I go to the Apple store the next day, buy a new phone, and I'm up and running, right? There's no problem with that.
No.
We're in the
You
twilight
couldn't do
zone.
that, Your
So
Honor.
that's why I'm asking for an affidavit, okay? And I don't have an affidavit from you, right?
I
Judge,
think
you
they
know,
do.
we have provided so much to the Commonwealth, asking for the phones back. We were under the impression they were not searched yet. You know, you got to remember that we were under the impression they were not searched yet. So we wanted either a mirror image of the devices or the devices back, because that's what the Commonwealth does in these cases, is they have the ability to give the phones back. There's no issue with the fact that the Commonwealth can take a mirror image of a device and then return the devices.
Because they gave
In
Brian
the series
Walsh's
of emails,
devices in
Attorney
24
Mello
hours.
said, no, we're not returning the devices. We're not giving anything back. And Judge, and also in terms of the items in the phone, Judge, it's not just the journalistic tools of the trade. It's that we needed to use the phones to defend Mr. Kearney against these allegations. They're looking for evidence of these supposed instances of witness intimidation. We need to look at them and push back and look at the phones to defend Mr. Kearney. I mean, it's not just the journalism issue. It's that this is evidence that we still, to this day, 11 and a half months later, we still don't have.
Yeah.
We still don't have it. So this motion that I'm before the court on is focused on unreasonable delay.
All right.
Not prejudice, unreasonable delay. And so, but there is prejudice, and I think I answered you that we can't defend Mr. Kearney, he can't do his job, and these people are the targets of Mr. Kearney's. This goes to the conflict of interest that's been throughout this case all along, Your Honor, is that these are the very investigators that are supposed victims in these 16 indictments in the 23 case. and yet they're still the investigators on the case. And they're targets of Mr. Kearney's reporting. Mr. Kearney's reporting is in his devices, and they go steal his devices. This thing stinks, Your Honor. So
really
Mello delays the first month into late November of a year ago, Your Honor, saying no.
So let me just focus you on the law for a second, okay? As you know, the Commonwealth submitted an opposition that describes at length that the cases that you recite and rely on are not cases where a warrant was authorized for the seizure of the device and search of the device. And here we have that situation. Are you referring me to any cases that deal with the timeliness of a search when authorized by a prior warrant?
I anticipated you would be concerned about that issue, Your Honor. Here's my answer. There are no cases, no appellate cases in Massachusetts. I couldn't find a case across the country where a investigative team had a warrant and then sat on it, didn't disclose anything to the defense for over a year, and was suppressed for unreasonable delay. There's no case where an investigative team did that. I think that's probably a good thing. This is an anomaly that, in this case, the investigative team got a search warrant, searched 2 of the devices, lied about it, kept it from us for almost a year, and then sat on it and didn't share any of the stuff with us, and pretended that they didn't search the devices to us until 9 months ago.
Is there a trial date in this case?
He doesn't know anything about the
No,
case.
Your Honor.
No. Okay. Usually, delayed disclosure is assessed against the prejudice to one party or another, and here we don't even have a trial date yet. So obviously, this stuff is going to be disclosed ASAP, right? Whatever was imaged and extracted from the phones in October is going to be disclosed
October
ASAP.
of 2023.
And we're going to talk about a schedule for that.
2023.
And obviously, if there's going to be a search of the other devices, there's going to need to be a taint team at least to evaluate your argument that there is attorney-client privilege material on the phone, on the devices, right? That's going to have to be resolved, and that's going to have to be done on an expedited basis.
He's got files on his hard drive that he needs
but
to do his
am
work.
hard-pressed to understand the basis for your suppression motion.
Judge, let me talk about the unreasonable delay. It's cited in my brother's memorandum, and it's the bedrock principle is that reasonableness is the touchstone of every search. Reasonableness. Unreasonable delay, the case law talks about, all the cases talk about when a phone is seized without a warrant, but the delay in getting the warrant. And that delay is never, there's some outlier cases where it's a few months that they allow it. But the most of the case law, and it's all cited in my brief, is that it's 2 weeks, 3 weeks, a month. That's it to get the warrant and get the search.
Right, without a judicial approval for grabbing something that belongs to somebody else, seizing it,
right,
and hanging on to it for investigative purposes, you need a judge to say that's okay. And essentially, that's what happened here.
Yes.
Right? A judge said it's okay to seize these devices from Mr. Kearney.
Yes.
And then,
but where reasonableness is the touchstone of every search, reasonableness still applies. And reasonableness doesn't allow the Commonwealth, in this case or any other case, to sit on evidence and deprive us of evidence for over a year. How much they searched it, they've obfuscated it all over the place. At the time, we were under the impression nothing was searched. And then Attorney Bederow's letter of 1017, Your Honor, that you referred to, that's around the time when we first realized, not from the Commonwealth, from a whistleblower from the Stoughton court, who supplied us with an extraction dated 1013. That's how we learned that the devices were searched. Up until that point, even Mr. Cosgrove was in the dark about that these were searched. Mello lied about it. He knew about it 100% because he authorized, according to Tully's testimony, he authorized the extraction to go to the Stoughton court back in October of 23. So
23, good, pointed out.
So there's no question that Mello knew about this. It still didn't disclose it and misrepresented to the court that these phones were not searched. So we were misled as to the fact that they were searched.
All right, I think I understand your argument. I should hear from Mr. Cosgrove on the issue of motion to suppress, and then I'll hear on the 1417 motion.
My last point, Judge, if I may, is that reasonableness doesn't go away. And the fact that they got a warrant and then did nothing for a year, that has to implicate reasonableness, Your Honor. And if you use the warrantless cases as a yardstick, this amount of time, Your Honor, is insanely beyond the pale and was done for an ulterior motive of violating Mr. Kearney's civil rights and depriving him of the ability to start defending himself. Thank you, Your Honor.
And that's clear.
Attorney Cosgrove.
For the record, 627 is in law.
Thank you.
I will be brief, Your Honor, and confine my remarks to just a couple of comments. I don't take from Your Honor's questions to my brother that you necessarily have made any decision about my arguments, but I do take from your questions that you've read my memorandum and understand the essential points that the
I don't think he did.
The Commonwealth has sought to make, chief of which is that
he doesn't even seem to know there's a motion filed.
Mr. Bradl came into the case, and before he made any request in terms of setting up a taint team, and even then made no mention of attorney-client privilege, the phone had already been searched. It had been downloaded. Lieutenant Tully had looked at it. Attorney Mello has not looked at the extraction report. I have not looked at the extraction report. But certainly in terms of purposes of the law of search and seizure, once the phone extraction is made and once the report was perused, certainly by the time the report was perused by Lieutenant Tully, it had been legally completely searched. So from my point of view,
then give it back.
Whatever the reasoning was back at the time, whether Attorney Mello didn't quite understand the significance of the Cellbrite report or for whatever reason, I don't understand, frankly, why there would be any purpose at that point to have a tank team after the cat was out of the bag with respect to those items. There certainly would be a purpose at whatever point Attorney Bradl represented to Attorney Mello that there was privileged attorney-client privilege material. In stopping any further search, we still had, I think it's 4 additional cell phones, the exact number escapes me, that were found in Mr. Kearney's closet, and we still had a laptop computer and some other paraphernalia that had not been searched. Mr. Mello's initial representation to Mr. Kearney that the Commonwealth would cease further search, I think was precisely accurate. I think some of his later statements are fairly susceptible to interpretation. He seemed to go back and forth between saying, we'll cease further search, or the devices have not been searched. And even that statement is true if you're talking about all of the remaining devices other than the 2 cell phones that were searched. I emphasize that there has been no harm to the defendant. He has plenty of time to examine the Cellbrite reports.
No harm. You've had his stuff for over a year.
Look at them, and I represented in my memorandum that I would not do so until he had a chance to bring the issue before this court. But I have here on a thumb drive both of the Cellbrite reports, and there's no need to set a deadline for the Commonwealth turn that over, Your Honor, because I'm going to hand it to Mr. Bederow right now, and I'm pretty confident that he will share those with Mr. Bradl, and they can go through those reports to their heart's content. And if there's any privileged material, whether it's a reporter privilege or attorney-client privilege, although, as noted, Lieutenant Tully did not find any, that they want to raise an issue about.
Lieutenant Tully didn't find any.
They have
Lieutenant
available
Tully.
to them the usual remedy, which they can back up based on the Cellbrite reports. They can bring it to the attention of the court, and they can move to suppress it as is normally done. And the search of those phones at least cannot be said to be subject to undue delay. The only undue delay, it seems to me, and the only prejudice is that after telling Mr. Bradl we would not proceed with the exception of responding to the request of the clerk of Stoughton District Court and turning over a couple of pages of the Cellbrite report that were pertinent to her inquiry. The Commonwealth has made no use of that evidence. Certainly,
Really?
It would have been helpful to us in a grand jury presentation to have had the contents of that report to present to the grand jury.
You did.
But no
I hope Mark
specifics
starts
with
talking.
respect to that report were essentially provided.
How long do you say the Commonwealth has to execute a search warrant or to conduct a search
Mark's
on
got
a
to be
digital device
chomping at the bit.
once a warrant for the seizure and search of that device has been issued? So it's the search warrant was executed on the October 11, something like that.
2023.
And
2023.
that authorized the seizure of many devices, 2 of which were searched, many were not. How long does the Commonwealth have to search those other devices or to seek to search those other devices?
Well, there's a couple of aspects to Your Honor's question, and please remind me if I forget to address one of them. One thing I should point out is that there were multiple warrants. So one warrant basically covered the cell phones. 2 of those, Your Honor, were the ones that were searched immediately. So there's no timeliness issue with respect to those. The rest of them have not been. The delay has largely been because of 2 factors. One, because we acceded to Mr. Kearney's request that we set up a taint team. And then there has been, I think, a delay in setting up the taint team, and I say this in
A delay?
in explanation, not necessarily an excuse, because it is the Commonwealth's responsibility, and that has further delayed matters. When Mr. Bradl brought the matter to Judge Calladane's attention back in I think it was July, but it was, I believe, our second appearance before Judge Callahan in the context of complaining of a discovery violation. Judge Callahan set a date for the Commonwealth to file a proposal, and I filed a proposal. And I don't think we can be charged with any delay relative to that point.
Oh, really? You have his kids' iPads too.
There is a difference between the 4 remaining cell phones, which are covered under the first warrant, which authorized both search and seizure, and the remaining items that were seized, in that Lieutenant Tully did not apply for authorization to search, merely to seize. So that portion has been executed. There needs to be another warrant filed.
What? Over a year
which
later?
we would propose to do at whatever point the taint
They
team
never
is
got a
approved
search warrant? You got to be ducking kidding
whatever
me.
earlier time Your Honor would suggest to authorize the search.
Good. Then exclude
As
everything.
to how long the Commonwealth has to accomplish this aspect of it, I'm not aware of any case law on the subject.
When Proctor wants a search warrant, he gets it in 20
our position
seconds.
is that in spite of the delay, there's been no substantial prejudice to the
Really?
defendant, and we're prepared to go
No
forward
prejudice.
on it.
Okay.
Please, Mark,
Thank you.
start talking.
With respect to,
I'm embarrassed.
the motion under Rule
For them.
14 and 17,
Judge, before we leave it, may I just respond just briefly to my brother's comments?
My
2
brother.
minutes.
They
Thank
call
you very much,
attorneys
Your
my
Honor.
brother, and
So, Judge,
sometimes
at a minimum, the fact that they still haven't sought the warrant for the balance of the devices, that does fit exactly under all the case law that I cited and
in the motion that you
completely
didn't read, Judge.
beyond the pale in terms of the delay to seek that warrant to get into those devices. That, there should be no question whatsoever that those are suppressed as a matter of law, where they didn't seek a warrant to get into those devices and were over the.
Do you have a case to that effect where the warrant is authorized for the seizure of the devices, but a second warrant is envisioned for the search of the devices?
We're envisioning it for
and that is delayed.
ducking
Do you have
year.
a case to that effect?
I argue by analogy, all the cases.
But by analogy is different. The analogy is to cases where there was never a warrant for the seizure of the device, and therefore the person is deprived of the use of that item without the any kind of a court determining that that's what should happen. But
I would argue it's the same thing, Judge.
all right, I understand the argument if it's only by analogy. Okay.
And the 12-month time period, if you look at the judges, is extremely well past all the case law. And the last thing I want to tell the court judge is that I found the citation on the journalist privilege. I'm just emailing Madam Clerk with a CC to counsel.
What is it?
This is insanity. This is insanity. We're in the twilight zone. The twilight zone is real. Lunatic
Petition
fringe.
for promulgation of rules regarding the protection of confidential news sources and other unpublished information. 395 Mass 164 at 171, 1985, holding that a judge must balance the public interest in the use of every person's evidence against the public interest in protecting the free flow of information, and indicates that before ordering a reporter to divulge source and information gathered, a judge must first, quote, consider the effect of compelled disclosure on values underlying the First Amendment and Article 16. So that's what I would cite in support of the idea that it's not just preventive medicine. There are all sorts of protections in the law. Journalist material, there's likely husband-wife disqualified.
Okay. All right, I understand.
All kinds of material in.
Okay.
Oh, now you're picking up
Thank
what
you.
he's laying down now?
If I may, Your Honor, just on that last point,
All right.
and I don't mean to try Your Honor's patience. I would just say the whole line of cases protecting documents, physical documents, when the Commonwealth is contemplating, say, a search of an attorney's office, or has reason to believe that there's going to be attorney-client privilege implicated. And that's where the taint team idea comes in. It's not a novel thing with respect to
We're still in the idea stage.
searches of electronic devices, although preventative medicine is the case that applies that to electronic devices in Massachusetts. But normally when the police go in to search a home, there may be all kinds of theoretically privileged material, doctor-patients, you could go through the whole list. But normally what happens is the police go through that material in search of whatever they're in search of, and that when we come around to the court, if the defendant has a privilege that he feels would bar the introduction of that material, he brings it to the attention of the court. But there's no procedure that I'm aware of where you screen for every conceivable privilege in the world.
Okay. With respect to the Rule 14, Rule 17, Mr. Bederow?
Go, Mark.
Thank you, Your Honor.
Here we go.
We recognize that this is an uncommon task to ask to seek to review the email of the elected district attorney. But this is an uncommon situation, and it's a situation that the district attorney himself created entirely.
And it was created by an email that he sent, or a communication that he sent to the district court chief justice and others about a potential leak of information from the Stoughton District Court.
On his private email.
Okay.
Your Honor,
Oh,
there is also evidence.
Let's assume it was his office email. The analysis wouldn't be any different, right?
The analysis wouldn't be any different,
Okay.
but we would have no reason to suspect that this was occurring. And in the context of seeking a Rule 17 subpoena and what is considered phishing and not, it is not an everyday situation where somebody just starts demanding the email of the district attorney because maybe he did something. What I'm suggesting to the court is, on that one example, on his private email, which we believe could lead to the inference that that is designed to subvert public records laws, that he sent that, and most importantly, that email directly talks about Mr. Kearney in the context of alleged witness intimidation, communications from witnesses who are going to testify against him, and an email which also included text messages from Jennifer McCabe, who is a key witness against Mr. Kearney. Additionally, since this motion has been filed, we even learned just last week from the Karen Reed hearing that Mr. Morrissey uses his cell phone to communicate directly with witnesses in the case against Mr. Kearney, and those materials are going to be provided to Ms. Reed's attorneys. But we also learned that as it relates to Mr. Morrissey's use of his cell phone, that he set his phone, his iPhone, and our subpoena would be to Apple, he set his iPhone to a setting to auto-delete all of his messages every 30 days, which I would suggest to this court is further evidence, possibly, of an intent to deprive what ought to be discoverable, whether it be in Rule 14, which we'll get to, or in getting access to relevant communications from his private server. When you factor in together, and this is an important backdrop before I get into the factors.
Do you think his server maintains the content of his communications that he auto-deletes?
I'm sorry?
You think his server maintains copies of the content of his communications that he auto-deletes?
I believe that Apple has the ability, absolutely, to maintain deleted messages.
Do I have an affidavit or anything else from you to that effect?
No, you don't, Your Honor, but I would.
Do I have any factual submission that we'll find anything in the content of an Apple subpoena that we couldn't otherwise get from Mr. Morrissey?
Well, I'm going to get to that when I get to the Rule 14, certainly as an alternative argument. But to answer Your Honor's first question, every day in this court and across the country, when you hear about so-called Celebrite extraction reports, deleted messages, of course, appear. They do remain on an Apple server. Just because the user may delete them from their device, I would suggest to the court and anyone else that those messages we've all seen can be pulled back and just don't simply delete.
You want me to take judicial notice of that?
I'm not necessarily asking you to literally take judicial notice, other than I would suggest that is a very common thing. And one should not assume that just because a user deletes an Apple message from their phone, that it is somehow lost forever. The purpose of me mentioning to Your Honor the text messages at all leads to why we want Apple to capture the universe of the email communications that we request from Mr. Morrissey. The fact that he does have it set up to auto-delete, the fact that he does use private email to access business, doesn't give us confidence, respectfully, that things are going to be preserved for public records or for disclosure to defendants. Additionally, Your Honor,
More
We
sign.
now know that the use of the iCloud email by Mr. Morrissey to conduct business is not a one-off. It is not simply the
Not a
one
one-off,
message
he said.
that ended up in the hands of Mr. Kearney's defense by way of a third party. And I will address this, as I'm sure Your Honor will have questions about a public records request and a response to that as being relevant to whether information is procurable from another source. But it's simply important for the court to know that we now have irrefutable proof by somebody who did a public record search, I have learned, and received some degree of a response from the district attorney's office, that Mr. Morrissey has been conducting business on his personal iCloud account since at least 2020. And the last email that was turned over as part of that public access request just happens to be the September 2023 email regarding Mr. Kearney, along with one response from, I believe, the chief judge saying you need to raise this with the Stoughton District Court.
Oh, they got a response
It
from
is in
that?
that backdrop, Your Honor, that we require a Rule 17 subpoena for this iCloud account because there is just no reasonable basis to believe that all of the information will be maintained and will not disappear based upon his use of the private server and his auto delete of the text messages.
In other words, Marcy can't be
As far as
trusted.
the relevance under Rule 17, it shows again his direct contact with witnesses and with officials regarding things that directly relate to Mr. Kearney and his alleged witness intimidation. Notably, the email in question was sent on September 28, 2023. There are documents that are exhibits in the letter that I wrote on October 17th, which I know Your Honor has read, that indicate that Mr. Morrissey had already recused himself officially from all matters involving Mr. Kearney by the 26th of September at the absolute latest. This information, if there are other messages, would be relevant to show his personal interest in seeing Mr. Kearney prosecuted after he had been recused, the bias of his office, and as Mr. Bradl referenced earlier, the bias of the very witnesses in this case, both police and civilians. Additionally, as Your Honor has taken the suppression undue delay motion under advisement, accompanying the email that was disclosed by the clerk of the Stoughton Court to a former clerk of that court included pages of the extraction report that we now know existed as early as October 11th, 2023, which was only disclosed to the defense on December 2nd, 2024.
Today.
There could be relevant information contained therein that could very well shed light on whether any shenanigans, as Mr. Bradl alleged, occurred in why cell phones that were searched, at least two, as the Commonwealth now concedes, at no time were ever disclosed, and indeed representations were made again and again and again, suggesting they were pristine and unsearched. As far as not otherwise being procurable in a reasonable manner, the obvious response to that would be, well, if there's a public records request that was satisfied, then, you know, you go through that process, and isn't that another way? And in these circumstances, for some of the reasons I said earlier, we don't believe so. Number one, the person who answered the public records request is literally an assistant district attorney who is literally a subordinate of Mr. Morrissey and reviewing their boss's email. Now, if something were to come...
It's no different than any other Rule 14, right? I mean, the office has an obligation to turn over any discovery materials, right, in the office.
Yes.
An assistant DA reviews the files. That includes the DA's files and anybody else who's, you know, part of the prosecution team. It happens day in and day out, day in and day out.
It does, but Your Honor, respectfully, what does not happen day in and day out is the elected official district attorney who has been recused from a case, is talking about the very case, talking to the witnesses, talking to the detectives. That is absolutely not normal.
That's right.
And in the normal review of discovery, which we'll get to in a minute with Rule 14, I don't believe it is normal for somebody to say, let me look at the district attorney's email. There would be no reason to even suspect that, let alone his private email and private text messages. This is, as I said earlier, Your Honor, not a common case or situation at all. Now, having reviewed the response to the Freedom of Information request, it is clear that there are materials that were withheld. Now, I suppose we could go.
What Freedom of Information request? You made one?
I did not make.
Who made the Freedom of Information?
I don't know who literally made it, but it has come in.
What is it that you're talking about that you're reviewing or that the court should consider with respect to freedom? Who made the Freedom of Information request?
I don't know who made it, but it is certainly.
What did it ask for?
It asked for Mr. Morrissey's email.
So you must have the written letter that was the request.
I do, sir.
Who was it signed by?
It is signed by Brandon Hunt, Assistant District Attorney.
Okay, so the Brandon Hunt, the ADA, made a public records request.
No, signed the form. I misunderstood Your Honor's question. It's an anonymous person with an email, a Gmail account.
An anonymous person made a public records request.
Yes.
Okay, and that was responded to by an ADA.
Yes.
Okay, have you made a public records request?
No.
Okay, why not?
Because I make
You're
motions,
relying
Your
on
Honor.
an anonymous email public records request?
Judge, I'm relying upon the response of an Assistant District Attorney who has responded to that and supplied.
Have you seen the request?
Have I seen the actual request?
Yeah.
I have not,
Okay, so how do you know what was asked for?
because they supplied emails, Your Honor, 200 and something pages from 2020 to 2023. The reason why we could make that request, it's going to be the same response. We have to review those materials. They're withholding materials as is indicated in the letter. We could appeal that determination. That could lead to somewhere else. That could lead to litigation. And I would suggest to this court that it is not a reasonable opportunity without the risk of delaying this for months and months and months.
What's unusual is somebody coming into court here relying on an anonymous public records request made by somebody we don't know,
You're shaming
requesting God knows
him?
what. You're coming in here as an officer of the court saying, I should rely on that, and I should rely on the response. That is very unusual.
Well, that may be, Your Honor. What I'm simply saying is I'm not asking you to rely on anything other than, and I believe these emails have been actually supplied in another case. So the prosecution obviously is vouching for the records that were disclosed. They've been turned over, my understanding, under a protective order in another case. I don't think Mr. Cosgrove is going to dispute that. It is signed by an assistant district attorney. What I'm suggesting is to go through this process when the person who is determining what that evidence will be is the elected official subordinate combing through his email, that we lack confidence in that, Your Honor.
All right. It seems to me that this can be handled as a Rule 14 request, no different than any other Rule 14 request to a prosecutor.
If it prefers the court, I will certainly jump to the Rule 14 components of this.
Mm-hmm.
And what is it that you would be making the request for under Rule 14, and why should I consider it before you've made the request? I mean, a Rule 14 is a discovery request. You say, we want X, Y, or Z. Have you made a Rule 14 request?
Many, Your Honor.
And where will I find those? And do we have a motion to compel the Commonwealth to produce certain discovery that was requested under Rule 14?
Judge, they are referenced in the letters that were sent to Mr. Cosgrove, to which we have received in his response papers some degree of a response, and that he agrees to provide us with text messages.
Okay.
So I believe, certainly Mr. Cosgrove is aware of our demand.
But I am not. You're asking me to compel Rule 14 discovery, and I don't have the requests submitted to me.
They were made in August of 2024, Your Honor.
That was a follow-up.
So,
It was a May discovery.
all right, but I don't have those. We're going to go back to those discovery motions and revisit those now? You prepared to argue those now?
Yeah, let's do it.
I mean, I'm prepared to have you talk about discovery issues, see if you can resolve them, and if there's anything that the court needs to resolve with respect to emails from the district attorney or any subordinate of his, or other kinds of discovery that there's a dispute about, I'm happy to hear you. But it seems to me in the first instance, you folks ought to talk about it and see if you can resolve it. Does that make sense?
It's been over a year.
Okay. All right. Are there any other motions that I need to deal with?
Not in the defense, Your Honor.
Okay. Let me just see for a second.
This is wild.
What is the status of the request for the taint team and how that would proceed with respect to the other devices if the motion to suppress is denied?
Your Honor, counsel filed the revised taint team proposal the last couple of days. We haven't had a chance to go over it or address it. And we would just object to any, the record on that point, we object to any further searches. We object to, the idea of providing us with this stuff here in open court on December 2nd.
All right, here's what I'm going to do. I'm going to see you before Christmas, and you folks are going to talk about the protocols, how it will work. I'm going to get you a decision on the motion to suppress, and if there is going to be further searches, we're going to have to deal with that at a hearing before Christmas, so that the case is moving along. You have now the disclosures of the contents of the extraction. And I can hear you on a motion if you're ready for that, okay, on things that you feel like should be suppressed. But I think that's pretty quick for you to pull that kind of thing together. But at a minimum,
not
you
really.
folks ought to be in a position to figure out a taint team protocol for review of other devices if they're going to be searched. And you should also discuss any outstanding discovery disputes that I need to deal with.
They don't respond to my letters, Judge.
Let's talk about a time when you folks can be back.
The motion to suppress was filed September 25th, 2024.
I'm happy to do that, Your Honor. There is another motion that I filed that I'd like to be heard on.
Sure.
Sidebar.
Sure.
Sidebar. This is wild, you guys.
Judge, suggesting that we have a hearing across the street in Devon District Court on Tuesday the 17th.
What time is that?
That's a 2 o'clock hearing. Judge, I'm here in this building at 9 o'clock for a motion to suppress with Judge Kearney. Could we maybe suggest, I'm trying to do my best. I have court every single day up until Christmas, until I leave for Christmas holiday. But perhaps if I suggest December 17th, we're all sort of in the neighborhood, maybe an 11 o'clock call here. That be all right?
How about 3:30?
That's fine. That's fine with me.
What's
Just give me a moment, Your Honor.
Yeah, sure.
So you know, I'm here at 9, motion to suppress across the street at 2 for Rule 17 in District.
All right. And lunch down the street.
lunch down the street?
December 17th is fine, Your Honor. 3:30.
Okay. Yeah, 3:30. We have a long list, I know, on the 17th, and I'm supposed to impanel a jury in the morning. So I don't expect to be able to fit you in the morning. We're clear in the afternoon? Oh, perfect. Okay, so let's say 3 o'clock. So you can finish your 2 o'clock and come across the street, and we'll deal with this. I don't expect it's going to be a long hearing because I think most of these things are going to work out. But
Really? You think they're going to just turn
right.
over Marcy's private emails
Okay.
without an order? I'm not so sure.
okay, there's another matter that you wanted to address at the sidebar, Attorney
Yes,
Cosgrove?
and
The
again, if I
sidebar.
could just have a moment.
Sure.
The sidebar. This is a joke, Jessica. I think this is a joke. This judge walked in here having no idea what was going on with this case. This is the risk. This is the problem with having a different judge sitting in this criminal part every week, every hearing. It's a different judge. It was Judge Katie Rayburn last time. Now it's Judge Peter Krupp. I don't know if they rotate their judges in this criminal part. This is like criminal 1, I think, in Dedham, in Norfolk Superior. This is insane. Stephanie's a retired attorney. Says, I've never encountered a judge more unprepared for a Monday morning docket, and I'm including the ones who showed up drunk to court. Stephanie, I thought it was me. Thank you for validating my feeling of this guy has no idea what's going on. I don't even think he realizes that they're saying they seized his devices in October of 2023, and now Cosgrove is telling, they're outside bar right now, so don't worry. And now Cosgrove is telling this court that he never got a search warrant for those additional 4 devices. They only had a seizure warrant in over a year. And the judge is like, oh yeah, so what's the prejudice of that? Where's the prejudice of them having his devices? He can just go buy a new phone. Are you ducking kidding me? They took hard drives, right? They took laptops. They took his kids' iPads. A lot of people have stuff downloaded like I do on external hard drives that I don't have anywhere else. That is my backup. My external hard drives are my backup. You can't really keep your legal documents in a cloud somewhere because, as you know, stuff is getting hacked left and right. So to suggest that there's no prejudice because he can just go out and buy himself a new phone is wild to me. It's wild. I don't know any attorneys that keep their files. Well, he's a reporter, so maybe it's different. But everything is hackable nowadays, as you know. Everything gets hacked. You don't keep your files as a lawyer, or I would assume as a journalist, on a cloud somewhere and hope that nobody hacks into your stuff. So that's wild to me. This motion to suppress for unreasonable delay was filed in September, and the judge had no clue. He's like, "What? Is there even a motion? Is there even an affidavit?" Yeah, it's right. Where would I find that? I don't know. In the duck and file that's on your desk? In the duck and file that's on the laptop on your desk? How about that? And I feel like when Bradl was up there, he was taken aback because he's kind of like, what the duck? What do you mean? Of course, it's right there in front of you. We've been arguing about this for a year. Wow. Wow. I don't know that Mark can really come on to talk about this. He really can't come on to talk about this. You got me, Susan. You're stuck with me. Mark can't come on and talk about this case. He doesn't have that, a lot of things are privileged. He can't be talking. Trash talking the judge, let's just say. And knowing Mark, pretty sure I know what he's thinking, but he can't come on here and talk about it. Happy holidays, blessed mom. Sounds like the judge has a case of the Monday, says Romy. Thanks, Romy. Thank you, Bianca, for your super sticker. YouTube strike notification of full screen. I don't know what you're talking about. Joseph Taylor, thanks for your super sticker. Kirsten, thank you, who is also formerly known as Auntie Bev's verdict form. So they can drag me all they want. If it means Mick uncovering the truth, I would rather be hated than be the hater. Karen is factually innocent. Thank you, Bianca. Thank you, Emily, who says, someone pinched me. This can't be real. Oh, it's real. Trevor said, unleash Bederow. He was unleashed. Nothing's happening again. It's like, okay, more delays. Commonwealth was busy this weekend, apparently, says Tracy. Can't say it enough. What the duck, says Laura. Hi, Laura. Storm Dancer. We know more about this case than the judge. That's kind of scary, isn't it? That's really scary, Storm Dancer. Good morning, Mel Klomp. How is this system ever to be taken seriously with a judge like this? I'm so disappointed. I'm just so disappointed that it's like a different judge every time. Like every day is a new day. You got to relearn everything all over again. It's like, what are we doing here? Did you file a motion? Where are the papers? And then Cosgrove has the cojones to say, oh yeah, well, those other devices, yeah, we never got a search warrant for those. We got a seizure warrant, but we never got a search warrant. Okay. I can't even believe that that's a good faith representation to the court at this point, based on all the fighting that's been going on about trying to get these devices back. We know they extracted Brian Walsh's cell phone within 24 hours, and he is accused of chopping up his wife and putting her in plastic bags throughout Norfolk County. So he got his devices back in 24 hours, Your Honor. What the duck? You've got the extraction. Give the devices back. The Rage Crochet Club is in full swing this morning. Hi, Rage Crochet. Thanks for the 5. Do all prosecutors in Norfolk County have the personality of a wet paper bag? First Lally, then Brendan, now this guy. Hashtag Rage Crochet. This guy is now like the second special ADA on this case because Ken Mello is, who knows where Ken Mello is. I still am asking for proof of life. I still haven't seen it. If anybody has proof of life on Ken Mello, please, we need a picture. Blank if you're in trouble, Ken Mello. We don't know where he is. And now we got Robert Cosgrove, who's a former judge or retired judge or something such as like that. Sarah B, 'tis only a flesh wound. 'Tis only a flesh wound, Sarah B. Thanks for hanging out with me for 4 months. And do you have a shrubbery? A shrubbery? Tony became a new member. Welcome, Tony. Erica, 2 minutes. Is it normal to have a different judge every time? Apparently there is no normal. There is no normal in Norfolk County because here's the other thing that Mr. Bederow said was not normal. He said, and the judge said to him, but isn't this normal? Isn't this normal that you would just, make a FOIL request to get all the emails of the district attorney? And Bederow was like, no, it is absolutely not normal for a recused district attorney who had been recused by the time he's sending this email to all the Stoughton judges about aiding Kearney's case to communicate with other judges from his private email, Your Honor, is absolutely not normal. There's nothing normal about that. And the fact that either Judge Krupp didn't understand what the crux of this argument was even, or would even somehow suggest that that is normal, strains credulity. It strains credulity. Michael, thank you so much for your 5. Sue says, they moved the courtroom, which messed up the login. Oh, it wasn't your fault, Sue. I was just getting a little flustered, and you know who saved us? The Glera saved us. Thank you, Will, for saving us because we needed saving this morning. And I even called this morning, Suze, as I was running late. I was in the car. I called an office superior. I think I'm all on it. I'm like, hey, do you guys have the Zoom login for Judge Krupp's part today? And they're like, hey, hold on. And then they give me all the Zoom login info, and it was wrong. So thank you. I called Suze, so they gave me the wrong info. And nobody's fault, but Glera got it right. So good on Will showing me up like that. We got to do a Melanie and Will after dark. We're overdue. Michael Ricciardi, thank you. On the overall demeanor of the judge when talking to the defense versus the prosecution is utterly insane. Well, here's the thing. In order for him to grant this request, which he really doesn't seem to understand what the request is, by the way, he would have to be releasing like all of his cronies, all of his other judges' emails in response to Marcy's email. And, slippery slope, folks, slippery slope. But for him to actually even suggest to the Killer Bees, did you make a FOIL request? Your Honor, we're in litigation right now, and they have an obligation to turn stuff over to us. There's this case, this really big case called Brady, which Michael Marcy knows all about, by the way, because in those frantic letters that he wrote to Josh Levy starting in the spring of 2023 when he got wind of, because he has speed dial communications with the witnesses in this case, Your Honor, with the victims, the alleged victims like Jennifer McCabe on speed dial. We got, saying we got a subpoena to appear in front of a federal grand jury. Michael, what's up with that, Michael? Why are we getting subpoenas for a federal grand jury? And then that sets off a flurry of insane letters culminating in a hostage video from Michael Marcy, where he's in his conference room in front of a whole wall of books, a whole wall of law reporters, which are upside down, out of numerical order, in which it looks like someone is literally holding a weapon to his head off camera and saying, read this, dude. And he reads this weird statement in his office saying things such as, this has to stop. Michael Proctor was not at 34 Fairview on January 29th of 2022. Well, that was a little too British, but not enough Boston. But you know what I'm trying to say. And then he was like, Colin Albert was not there. These innocent witnesses are being terrorized, harassed, and blah, blah, blah. This needs to stop. In all of those frantic letters that he wrote to Josh Levy, he said, I have obligations. I have obligations under Brady. I have obligations. I have to turn everything over. I have to turn everything over that you have that could be in any way connected to the Reed case. So gimme, gimme, gimme. Gimme, gimme, gimme. I need it. I need it. I need it. I need it. This isn't a fishing expedition. I just need it because I have to turn it over to the defense team on Reed, on the Karen Reed case, READ, which in his email, he coincidentally, not coincidentally, he intentionally, maybe by accident or Scrivener's error, said Reed, REED, which is why we saw Misty and Eddie the other day. Misty and Eddie ask for, when they are doing the searches of Marcy's private emails, by the way, to search for not just Reed, READ, but also REED. And then I suggested through the computer, hoping that somebody heard me, ask for REID also. Because, you know, who knows? Or maybe, you know, whack job, search whack job up, maybe. And the C word, and, you know, other such things as, why this is not supposed to be buzzing and it's buzzing. I don't understand why. Other such things as that. We got to turn it all over. He knows his Brady obligations. This is whack. This is whack. So there at sidebar. Don't worry, we're not missing everything. But what I need you to do right now, please, because I love you with all my heart, smash the like button right now. Smash it, smash it, smash it. Because it helps the algo, you know, help a girl out. And also, I might turn off the air conditioning, although it's like cold here. It's like, let's see, 34 degrees here in New York. Let's see what it is in Dedham. Because, you know, we know there's people outside today. I didn't catch the pre-game. If anybody caught the pre-game this morning, let me know how many people you think are out there. It's 33 degrees in Dedham today with a real feel of 35. So it's cold. Denise says standouts are great, but fellow Massachusetts residents, join me in educating our state representatives, calling your government council rep and government incessantly. I'm not going to advocate calling anybody incessantly, but the opinions of my viewers are the opinions of my viewers and not mine. Kirsten, the fan blew all the papers off the judge's desk. Apparently, because the judge didn't even have like a laptop that he could even look in the court docket like I can do right from my desk right here to see what's already been filed in this case and when. They obfuscated all over the place, sua sponte tells us. Bradl said. Sua sponte. You guys have a competition for like best screen names. And it's a great one, Sue. Ellen says, please, can someone explain to me or the judge how it matters who filed the public records request when they have the response? That's a great point. I think he wanted to know what was actually requested. I think that's what the judge wanted to know. And without seeing the physical request, you don't know what is actually requested and what the actual response was to. So I think that's where he was going with that. So there's that. Kirsten, is there proof of life for Mello? I need to know too. I need to know. Lawyer's daughter, is it possible that the judge is feigning ignorance to delay discovery? Perhaps he's on the email chain. Seems too incredulous for him to be this out of touch. I'm verklempt. I'm again, it is like we are in the twilight zone. We are in the upside down. We are we are somewhere out in lunatic fringe is where we are somewhere. Any and all analogies are welcome. Hi, Dave Matthews, Band 22. Imagine a day where Karen or Turtleboy went to court. Something actually got accomplished that day. Thanks for the 5 DMB 22. I'm here to tell you as a lawyer who been practicing for over 30 years that this is the way it goes. Just the wheels of justice turn very, very slowly. And everyone's saying the judge is cranky, the judge is cranky. Judges are like that. That's how judges are. All the time. Not uncommon whatsoever. Not uncommon. Nothing different about it. He's making Judge Bev look like an awfully happy camper most of the time. So there's that. I mean, here in New York, there was a judge in Brooklyn who would not allow women attorneys to wear slacks in court. There was something else I saw the other day, and this was in Nassau County. There was a judge. If you wore your overcoat up when you were called up in the trial part, you would be berated. Like, I'm sorry, am I keeping you here, counselor? When you come up to the bench, you take your coat off. And I saw the other day in court, I forget what hearing it was, that one of the prosecutors, I think, or the defense attorneys, not in this case, different case, was wearing like a trench coat and just like standing up, making their argument with a trench coat. And I'm like, oh, that would not fly. That would not fly around here. Thanks for the 5. Spanky's hanky. See what I mean? Thanks for the 5. No judge in Norfolk wants to be the one to sign the Apple Records motion. They're all scaredy cats. Yeah. Interesting, right? Interesting. I mean, I'm assuming they're still at sidebar unless we have other information. Hold on. I got no volume. Tom CPU. His camera's up, but not seeing anybody outside of the courthouse yet. So, but apparently this judge, this Cosgrove made another motion. They're discussing sidebar. So I don't know what that is. Tracy, great question. Thoughts about journalistic privilege and lack of privilege in Massachusetts. Massachusetts is one of a handful of states that does not recognize any sort of journalistic privilege, which is also wild to me coming from New York, where reporters protect their sources. That's what they do. There is no such thing in Massachusetts. For one of the places of like the birthplace of this nation and democracy, Massachusetts, they are a little far behind when it comes to like, recognizing their citizens' constitutional rights. I'm just saying. Freedom of speech is a big one. It's a big one. Luckily, we saw the Second Amendment protected the other day when we watched the Brian Camp acquittal, which I urge you, if you have not seen that trial, please go back and watch it. We were only able to do like 3 streams on it because it was not televised. And then I had the amazing.
I just wanted, before we broke, Your Honor, I remembered that you referenced a need to see the search warrant affidavit. I filed a copy of the warrant pursuant to the cell phones when I filed my original proposal for a tape team.
Bad boys, bad boys.
I have an additional copy here that I'd be happy to hand up to the court.
All right.
Thank you, Your Honor.
You want to see what was just handed up?
We're fine, Judge.
Okay, very good. Anything else from the defense?
No, Your Honor.
Okay, we'll see you December 17 at 3 p.m. And I do hope that you're able to work out most of the discovery disputes and
you said 3:30
protocol.
before.
Thanks.
All right.
All rise. God save the Commonwealth. God save the Commonwealth. And that's the end of that. I'll keep Tommy up and see if he comes outside. He said 3:30 earlier. Now they're saying 12:17 at 3. So who knows? That's what I think about the lack of journalistic privilege. It does not make me happy. It does not make me feel all warm and fuzzy. It makes me feel like I would never give any reporter an interview who's based in Massachusetts or the Boston area, because nothing that we ever say would ever be off the record, not off the record. So that is why, my friends, when I do my show, which I intend to do maybe later today on this Phelps podcast, I think that the Phelps podcast, I've heard a lot of people hating on it. I did suffer through it for 8 hours of my life that I'm never getting back, although I put it on like double speed to listen to it. I do think that the Phelps podcast may, in my opinion, be very helpful to the Karen Read defense. And I'm going to tell you why, and we're going to talk about it. Tommy's a little... I'm going to wait to put Tommy up until something happens, because the audio is a little bit garbled. It's like, all right, here we go. But I need you to go give Seeking Justice with Tommy and Boston Mike a like.
Was it as biased inside as it was outside? Yeah? That bad? Not as bad as Beverly. All right. Yeah. Brutal. Yeah, you don't.
See if I can make this bigger for you. Maybe he'll get a quote from one of the Killer Bees on the way out, and or Aiden Kearney. Edward.
How is it inside? Good? Bad? Same thing? Just unreal, huh?
I think all the judges are afraid they're going to be on the emails.
Well, yeah, what if this guy's on the emails? Then what?
What's more in the tank for the prosecution than Bevins?
Then really that bad? Outside it was bad. We heard out here it was not good.
Yeah, no matter what Cosgrove said, he just let it fly, he nodded and
Yeah.
dreamed it. And sidebar too, they were talking about Katana, you could hear bits and pieces.
Okay.
And he was doing the same thing.
Really?
Bradl, listening to Cosgrove.
Wow.
It's Tommy's audio that's a little garbled. Sorry, guys, there's nothing I can do about it. But he's on the ground, so let's give him the view and the watch, please, after this. But he always says I can. Tom CPU is an amazing guy. He always says that I am allowed to restream him. Rage crochet.
Another ambulance. You freaking kidding me?
Yes, Stephanie. Stephanie, you listened to it too. Send me your thoughts, Steph. Send me your thoughts. Email me. I have so many thoughts about that. I have like an entire legal pad full of notes on that podcast. Don't hate on it, you guys. Listen to it. Especially like starting at, do like episode 7 and 8, if nothing else. I went backwards. I did 8, I did 7, then I did 8, and then I went backwards to 6, 5, 4, 3. It's called 34 Fairview Road. And you need to put it on you can put it on like 1.5 speed, because a lot of it is not direct dialogue with the witnesses. A lot of it is court testimony that so many of you are already familiar with. We ain't got no quit. So, Tom CPU does rock. I mean, and he's so nice. He's so nice. One day he was outside of court and he was talking to Grant Smith Ellis, and he was like really, really nice to Grant Smith Ellis. Susan says, unfortunately, Krupp is the judge who was not like Aiden from the beginning.
All right, guys. Questions real quick. Any questions for Bradl or Bederow?
Court TV commentators on
Or Aiden,
Thrashing
for that
Massachusetts
matter.
Commonwealth. Are they on right now?
Question.
Like right now.
Okay.
Right now?
I get that question.
Oh.
All right. Does it sound better? I know, but they're saying I'm breaking up. That I'm on the stairs. It might be the building. I may have.
I can rewind, Tom. So let's put that. We'll put a pin in that. Not so much.
For the CC to council. What is it? It's
All right, we're going to hit the pause button right there. We have to hit a break, but
All right, so it looks like Court TV is on delay with this, and they are actually broadcasting it live. Unfortunately, what I cannot do really is rewind it, but maybe I can. Hang on. You mean to tell me that they had all right, this is why. Okay, this is what we had to do with the Brian Camp stuff. We had to suffer through the commercials
Magnesium to support my muscle and bone health. Quinoa's high absorption.
hang on, because we may be able to catch some of the video. And this is not being streamed live on YouTube, of course. It's only on their channel. So yeah, we'll watch it. So let's give it a second. I'm not going to make you suffer through the commercial. This is what we did with Brian Camp. We had to suffer through the closing arguments on Court TV proper, which is what we're watching right now. And they kept interrupting, and they didn't let us watch the whole thing. And then they wouldn't go back to like where they left us off. It was a mess. It was a mishigas. Making me watch this commercial, so just hang on. Ay. For the love of the traveling Mary. Yeah, more commercials. They don't let us go to real time, so we just have to. Oh, there's Olivia Benson. Love me some Olivia Benson. They're not coming out of the courtroom yet, so we're not missing anything. We did have to suffer through Julie during Brian Camp. Wasn't that crazy? Yeah, I know. You know why, Lucy? Because I stop and I interrupt them and I yell at them. I do. Yep. All right. Tommy still doesn't have anybody coming out yet, so they're getting like free advertising. I hate to do that too. Well, at least they had a camera in there, so there's that. Come on, man. I wonder if they're gonna have Big Case Mike on to talk about how much he hates Karen Reed. Do you remember that? That was so beyond. We're just gonna go back here for a minute. That was so beyond that Big Case Mike. And then they had Big Case Mike on during Brian Camp. And they were talking about, I mean, it was whack. It was insane. Maybe Court TV will post it later. It looks wicked cold out there. Hold on. Wicked cold. Oh, that's the guy from Canton Community TV.
Guys. Anything? If you're watching me on a wireless, sometimes your wireless is kind of the issue.
Thanks, Stephanie.
Wow. No, that's okay.
I don't know who Crime Weekly is.
If I don't know, I can't try and fix
podcast
it, right?
or what, but typically I don't promote other channels unless like I've vetted them thoroughly and know that
Colder over here by a lot. The wind.
I know. I mean, they're on like 5 minutes of commercials right now.
Bev has to move 12 to April.
But it's a commercial for Criminal Minds.
January may not be good. Do they? Gotta get them. I got a heated vest on right now.
Who likes Criminal Minds?
Oh, it's so good.
Any criminal? There's ST. Any Criminal Minds fans in the chat? So my daughters love Criminal Minds. They've all watched like every single episode like 3 million times. One of my daughters was going to go to Soho the other day to go shopping at Aritzia because apparently it's some store in Soho that every kid wants to shop at. And all right, we're switching back to here. Matthew Gray Glubler was on the street.
To the murder case against Karen Reed. She's accused of killing her Boston police officer boyfriend and claims that all of the charges against her is part of a massive police cover-up. Let's head back into court now where his attorneys are arguing the return of his cell phones.
The name of the case is Petition for Promulgation of Rules Regarding the Protection of Confidential News Sources and Other Unpublished Information. 395 Mass 164 at 171, 1985, holding that a judge must balance the public interest in the use of every person's evidence against the public interest in protecting the free flow of information, and indicates that before ordering a reporter to divulge source and information gathered, a judge must first, quote, consider the effect of compelled disclosure on values underlying the First Amendment and Article 16. So that's what I would cite in support of the idea that it's not just preventive medicine. There are all sorts of protections in the law. Journalist material, there's likely husband-wife disqualified material. There's all kinds of material in there. Okay, thank you.
If I may, Your Honor, just on that last point, and I don't mean to try Your Honor's patience.
I don't mean to try your patience. Trying our patience.
I would just say that there's a whole line of cases protecting documents, physical documents, when the Commonwealth is contemplating, say, a search of an attorney's office, or has reason to believe that there's going to be attorney-client privilege implicated. And that's where the taint team idea comes in. It's not a novel thing with respect to searches of electronic devices, although preventative medicine is the case that applies that to electronic devices in Massachusetts. But normally when the police go in to search a home, there may be all kinds of theoretically privileged material, doctor-patient, you can go through the whole list. But normally what happens is the police go through that material in search of whatever they're in search of, and that when we come around to the court, if the defendant has a privilege that he feels would bar the introduction of that material, he brings it to the attention of the court. But there's no procedure that I'm aware of where you screen for every conceivable privilege in the world.
Okay. With respect to Rule 14, Rule 17, Mr. Bederow? Thank you, Your Honor.
All right, this is Mark, when he first got up.
We recognize that this is an uncommon task to ask to seek to review the email of the elected district attorney. But this is an uncommon situation, and it's a situation that the district attorney himself created entirely. The court
It was created by an email that he sent, or a communication that he sent to the district court, chief justice, and others about potential leak of information from the Stowe district court.
on his private email, Your Honor. There is
Mark's
also
face.
evidence.
Let's assume it was his office email. The analysis wouldn't be any different, right?
The analysis wouldn't be any different, but we would have no reason to suspect that this was occurring. And in the context of seeking a Rule 17 subpoena and what is considered phishing and not, it is not an everyday situation where somebody just starts demanding the email of the district attorney because maybe he did something. What I'm suggesting to the court is
He
on
absolutely
that one
did
example,
something.
on his private email, which we believe could lead to the inference that that is designed to subvert public.
Going after DA Morrissey's private email because they say that he was using that instead of his work email.
He was,
and
Matt, he
transferring
was.
Information. But let's bring in our guest for this hour, law enforcement expert Sonny Slaughter. Thanks for sticking with us. So I want to talk about the other person that's been brought up quite a bit, and that is Lieutenant Brian Tully. You remember he's the former
We
lead
remember.
at the Norfolk County DA's office, detective unit. He has since been disciplined, transferred out of that unit because he didn't crack down on his team and discipline them, including Trooper Proctor, who was the lead investigator in the Reed case because
Look at
of
the
his
nudes.
inappropriate behavior and text messages that he was sending within the office and his team. But how does that hurt this case against Aiden Kearney when you have the investigators that were confiscating his?
Will they let me even pause it? They will. Okay, if you're just joining, Court TV's on delay with the Aiden Kearney and Bederow and Bradl hearing, so we are watching it, but it's paused. So we just saw Mark Bederow get up and start arguing. Now they're going to bring in the talking head, Sonny Slaughter, who usually is not on my side, but he's talking about Tully right now. So let's listen to what she has to say about Tully and see if she surprises me this
His
time.
items in question. that they've been removed from their positions and disciplined.
Matt, this case has already made me pull out the books. I had to go to get some case law myself. So I think one of the problems could be whether there is the judge to rule on a good faith exception in the law there. And there is a case, Massachusetts versus Shepherd. And I was looking at it. And when you think about the leadership and how this is all unfolding and whether there's some question, the defense could potentially argue that the judge couldn't look at any good faith could not use a good faith exception because of the character and all of the dynamics that you just discussed involving these individuals. So when you take actual case law for Massachusetts and you look at what has happened with the character and the behavior and actions of these individuals, they might have an argument here for why this is problematic in everything that they've done, including why the search warrant didn't say it wasn't a search and a seizure warrant at the time, and why they think they can go back.
All right, let's see who I spy. I spy Meredith. I don't know who anybody else is here. Esty, she does a lot of standouts by herself, like in front of the, like, I don't know what building that is, but she's out there. She's got pom-poms and signs by herself all the time. Very, very, I have a lot of admiration for her. Go girl. There's Bederow, Bradl, and Aiden. So is she actually saying that there might be some sort of corruption in Norfolk County? She can't be. Hold on.
And now, this whole back and forth does not make sense. Why, if they thought they had something, why didn't they do it the first time? Search and seizure warrant and not just a seizure, and think they could come back and say, oh yeah, well, now we're ready to look at it.
See, even she thinks it's crazy.
And complicating the case even further. And Turtleboy might have a way to, suppress this evidence and information that they have.
And in short, we have about 20 seconds left, but do you think that these investigators that are now in question, relieved of their positions, will not be called in his case?
I think they will be called in his case to bolster their case.
All right. Sunny Slaughter, thank you so much. I know that you have a lot to do today on this busy Monday after the holiday. Straight ahead, we have more coverage out of the Commonwealth.
We have more coverage, but we're going to make you watch the commercials.
Known as Turtleboy.
Known as Turtleboy.
Growing up, my mom was a local news anchor.
She did say that there wasn't a search warrant. What there was only, and they said it in court too, is a seizure warrant. There was only a seizure warrant for like 4 of those phones. Tell me who this is being escorted out of, I was going to say out of camp, out of the courthouse.
Sure does.
Oh my God.
Wait.
What? No, who's walking out of the courtroom on the other side there?
That was Esty.
No, who's walking out of the courtroom on the other side there?
Big victim.
What?
Oh, that's Lindsay Gattani with an escort?
Oh my God.
With an escort. With an escort. Again.
She's got a court officer with her?
Sure does.
Oh, Jesus Christ.
Well, she is, the
come on.
victim in this case.
Good job, Tommy.
Tommy got it on camera. She's
negative.
I don't know, but she got to, she probably get walked to her car, don't you think?
Yeah, they always get escorts.
Unbelievable.
What? I mean, that doesn't make any sense.
That's wrong. That's just not right. Yeah.
Well, she was in there because she's the victim. It's the case. Her case, she's the victim in this case.
Yeah.
Well, Morrissey obviously told her.
Because she's on that. She's in his emails, man.
This case is about her.
Yeah. I wonder who's watching her kids. Who's watching your kids, Lindsay? Who's watching your kids, Lindsay?
Yeah, I'm not gonna promote that.
I know.
Where are your kids, huh?
Let's not harass anybody outside the courthouse, Tommy. It's just a little friendly.
Wouldn't doubt it. Jen's probably watching.
Okay. We'll just wait and see if anybody else comes out. While Court TV is on commercial break and we're waiting for those commercials to end so that they will take us back into the courtroom so we can see the video of the hearing. We listened to the audio on the Zoom side. Now we're going to get to see the video. Yeah, I don't like this part either. I don't like it. I just don't like it. I mean, everybody just needs to take a step back and just stop with the nonsense, because all of the hate and vitriol is really, really taking away from what's important here. And what's important here is the wrongful persecution of Karen Reed and now Aiden Kearney, because he was set up to go to jail. He was set up. He was set up. He spent 60 days in jail for something that was organized, orchestrated, and conspired between Ken Mello, Brian Tully, Kate Peter, and Lindsay Gattani. And that's where the focus needs to be. This could be the witness intimidation case. Yeah, this is in Superior Court, but peripherally, she's involved in this as well. Yeah, we don't dox. We don't do that. In fact, Team Brittany, I announced that I'm not covering that Hana Kobayashi case. A lot of people have asked me to, and based on everything that went on over the weekend, I'm just not going to do it. I'm not doing it because I'm not getting involved in that hatred and vitriol. I have enough coming at me from this case. This one we will cover, this Jamie Komorowski case, when it starts. If they're in jury selection, it's going to be a while. We actually were a little bit behind on this one. So we have some time. I don't know if they came out and did it and spoke to him. If anybody knows, let me know. I'll keep fast forwarding it in the meantime. All right.
A controversial blogger known as Turtleboy, Aiden Kearney, in court
Turtleboy
motion hearing. We'll go back to that in just a bit. Also, South Carolina, the trial for Jamie Komorowski set to begin today. She, of course, is accused of drunkenly crashing into that golf cart that killed a bride just hours after her wedding. The judge expected to take the bench next hour, 12:30. We will take you into court as soon as they are up and running. In Florida this afternoon, Sarah Boone facing sentencing for
yeah,
the
we're doing
suitcase
that
murder of her
at
boyfriend
1:30
George Torres, a case
Eastern.
we have been watching and monitoring for years. That 1:30. Will Sarah talk? We'll find out. And in California later this hour, a pretrial conference set in the celebrity stylist murder for Monica Sementelli, accused of hiring a hitman to kill her Beverly Hills hairdresser husband. Busy
that sounds
day.
interesting.
Let's go back to Massachusetts. More of the hearing for Aiden Kearney, known, of course, as
Kearney.
Turtleboy. We're going to pick it up right where we left off.
Yeah, see, we didn't miss a thing.
They had sent that, and most importantly, that email directly talks about Mr. Kearney in the context of alleged witness intimidation, communications from witnesses who were going to testify against him, and an email which also included text messages from Jennifer McCabe, who is a key witness against Mr. Kearney. Additionally, since this motion has been filed, we even learned just last week from the Karen Reed hearing that Mr. Morrissey uses his cell phone to communicate directly with witnesses in the case against Mr. Kearney, and those materials are going to be provided to Ms. Reed's attorneys. But we also learned that as it relates to Mr. Morrissey's use of his cell phone, that he set his phone, his iPhone, and our subpoena would be to Apple, he set his iPhone to a setting to auto-delete all of his messages every 30 days, which I would suggest to this court is further evidence, possibly, of an intent to deprive what ought to be discoverable, whether it be in Rule 14, which we'll get to,
possibly,
or getting access to relevant communications from his private server. When you factor in together, and this is an important backdrop before I get into the factors.
His server maintains the content of his communications that he.
They're coming out of court. I'm pausing it. We're not going to miss a minute. Let's just listen to this, because otherwise we have to suffer through more commercials.
I'm sorry?
You think his server maintains copies of the content of his communications that he auto-deletes?
I believe that Apple has the ability, absolutely, to maintain deleted messages.
Do I have an affidavit or anything else from you to that effect?
No, you don't, Your Honor, but I would suggest.
Factual submission that will find anything the content of an Apple subpoena that we couldn't otherwise get through Mr. Morrison?
Well, I'm going to get to that when I get to the Rule 14, certainly as an alternative argument. But to answer Your Honor's first question, every day in this court and across the country, when you hear about so-called Celebrite extraction reports, deleted messages, of course, appear. They do remain on an Apple server. Just because the user may delete them from their device, I would suggest to the court and anyone else that those messages we've all seen can be pulled back and just don't simply delete.
You want to take judicial notice of that?
I'm not necessarily asking you to literally take judicial notice, other than I would suggest that is a very common thing.
Although it sounded like he was willing to take it under judicial notice. I couldn't tell if he was being snarky. Might have been worth a shot, but maybe not.
And one should not assume that just because a user deletes an Apple message from their phone, that it is somehow lost forever. The purpose of me mentioning to Your Honor the text messages at all leads to why we want Apple to capture the universe of the email communications that we request from Mr. Morrissey. The fact that he does have it set up to auto-delete, the fact that he does use private email to access business doesn't give us confidence, respectfully, that things are going to be preserved for public records or for disclosure to defendants. Additionally, Your Honor, we now know that the use of the iCloud email by Mr. Morrissey to conduct business is not a one-off. It is not simply the one message that ended up in the hands of
Right.
Mr. Kearney's defense by way of a third party. And I will address this, as I'm sure Your Honor will have questions about a public records request and a response to that as being relevant to whether information is procurable from another source. But it's simply important for the court to know that we now have irrefutable proof by somebody who did a public record search, I have learned.
Yeah, this is where it gets a little
some degree
snarky.
of a response.
All right. If you didn't see this part, if you didn't listen to this part with me over Zoom, this is where it gets a little snarky. Court TV is behind, which is why we are getting the ability to watch it twice, but actually see video this time because the Zoom feed did not have video. So if you haven't paid attention or you weren't here before, this is where the judge is going to get snarky.
From the district attorney's office that Mr. Morrissey has been conducting business on his personal iCloud account since at least 2020. And the last email that was turned over as part of that public access request just happens to be the September 2023 email regarding Mr. Kearney, along with one response from, I believe, the chief judge saying you need to raise this with the Stoughton District Court. It is in that backdrop, Your Honor, that we require a Rule 17 subpoena for this iCloud account, because there is just no reasonable basis to believe that all of the information will be maintained and will not disappear based upon his use of the private server and his auto-delete of the text messages. As far as the relevance under Rule 17, it shows, again, his direct contact with witnesses and with officials regarding things that directly relate to Mr. Kearney and his alleged witness intimidation. Notably, the email in question was sent on September 28, 2023. There are documents, there are exhibits in the letter that I wrote on October 17th, which I know Your Honor has read, that indicate that Mr. Morrissey had already recused himself officially from all matters involving Mr. Kearney by the 26th of September at the absolute latest. This information, if there are other messages, would be relevant to show his personal interest in seeing Mr. Kearney prosecuted after he had been recused, the bias of his office, and as Mr. Bradl referenced earlier, the bias of the very witnesses in this case, both police and civilian.
Bias.
Additionally, as Your Honor has taken the suppression undue delay motion under advisement, accompanying the email that was disclosed by the clerk of the Stoughton Court to a former clerk of that court included pages of the extraction report that we now know existed as early as October 11th, 2023, which was only disclosed to the defense on December 2nd, 2024.
Today.
There could be relevant information contained therein that could very well shed light on whether any shenanigans, as Mr. Bradl has alleged, occurred in why cell phones that were searched, at least 2, as the Commonwealth now concedes, at no time were ever disclosed, and indeed representations were made again and again and again, suggesting they were pristine and unsearched.
Right. They lied, Your Honor. They lied. There will be no shenanigans, no tomfoolery, and no ballyhoo. Name that movie.
As far as not otherwise being procurable in a reasonable manner, the obvious response to that would be, well, if there's a public records request that was satisfied, then, you know, you go through that process, and isn't that another way? And in these circumstances, for some of the reasons I said earlier, we don't believe so. Number one, the person who answered the public records request is literally an assistant district attorney who is literally a subordinate of Mr. Morrissey and reviewing their boss's emails. Now, if something were to come...
It's no different than any other Rule 14, right? I mean, the office has an obligation to turn over any discovery materials, right? In the office,
yes,
an assistant DA reviews the files. That includes the DA's files and anybody else who's, part of the prosecution. It happens day in and day out, day in and day out.
It does, but Your Honor, respectfully, what does not happen day in and day out is the elected official district attorney who has been recused from a case is talking about the very case, talking to the witnesses, talking to the detectives. That is absolutely not normal.
No, it's not.
And in the normal review of discovery, which we'll get to in a minute with Rule 14, I don't believe it is normal for somebody to say, let me look at the district attorney's email. There would be no reason to even suspect that, let alone his private email and private text messages. This is, as I said earlier, Your Honor, not a common case or situation at all. Now, having reviewed the response to the Freedom of Information request, it is clear that there are materials that were withheld. Now, I suppose we could go.
What Freedom of Information request?
I did not make one. No. I don't know who literally made it, but it has come into.
What is it that you're talking about?
Here comes the snark from the judge. If you didn't listen to this on the Zoom, Court TV is behind, so we're watching this live on Court TV, but not live in the courtroom.
Reviewing whether the court should consider with respect to
Your Honor,
who made the Freedom of Information request?
I don't know who made it, but it is certainly.
What did it ask for?
It asked for Mr. Morrissey's emails.
So you must have the written letter that was the request.
I do, sir.
Who was it signed by?
It is signed by
Anonymous.
Brandon Hunt, Assistant District Attorney.
Okay, so the
That's the response.
The ADA made a public record.
No, signed the form. I misunderstood Your Honor's question. It's an anonymous person with an email, a Gmail account.
An anonymous person made a public records request?
Yes.
Okay.
You're allowed to do that.
Responded to by the ADA?
Yes.
Okay. Have you made a public records request?
No.
Okay. Why not? You're relying on an anonymous email public records request?
Judge, I'm relying upon the response of an Assistant District Attorney who has responded to that and supplied.
Have you seen the request?
Have I seen the actual request? I have not.
Okay, so how do you know what was asked?
Because they supplied emails, Your Honor, 200 and something pages from 2020 to 2023. The reason why we could make that request, it's going to be the same response. We have to review those materials. They're withholding materials as is indicated in the letter. We could appeal that determination. That could lead to somewhere else. That could lead to litigation. And I would suggest to this court that it is not reasonably, a reasonable opportunity without the risk of delaying this for months and months and months.
What's unusual is somebody coming into court here relying on an anonymous public records request made by somebody we don't know, requesting God knows what, and you're coming in here as an officer of the court saying, I should rely on that.
Oh, no, you didn't, Judge Krupp. Oh, but yes, he did. So let's listen to our friend Mark Bederow clap back to this. Buckle up, buttercups.
Now I should rely on the response. That is very unusual.
Well, that may be, Your Honor. What I'm simply saying is I'm not asking you to rely on anything other than, and I believe these emails have been actually supplied in another case. So the prosecution obviously is vouching for the records that were disclosed. They've been turned over, my understanding, under a protective order in another case. I don't think Mr. Cosgrove is going to dispute that. It is signed by an assistant district attorney. What I'm suggesting is to go through this process when the person who is determining what that evidence will be is the elected official subordinate combing through his email, that we lack confidence in, Your Honor.
All right, it seems to me that this can be handled as a Rule 14 request, no different than any other Rule 14 request to a prosecutor.
If it prefers the court, I will certainly jump to the Rule 14 component of this.
And what is it that you would be making the request for under Rule 14, and why should I consider it before you've made the request? I mean, a Rule 14 is a discovery request. You say, we want X, Y, or Z. Have you made a Rule 14 request?
Many, Your Honor.
And where will I find those? And
In the court
do we have a motion to compel the Commonwealth to produce certain discovery that was requested under Rule 14?
Judge, they are referenced in the letters that were sent to Mr. Cosgrove, to which we have received in his response papers some degree of a response, and that he agrees to provide us with text messages. Okay. So I believe.
All right, we need a break. We'll get you back into.
We
more
need a
of this
break. No,
motion
you need a break.
hearing
And I want to hear
for
Mark go
Amy
off about
Kearney.
how it's not normal
Kearney.
for a
That's
judge.
Kearney, Turtleboy, you can call him if you want. He, of course, is facing witness intimidation charges connected to the
Of
case
course he
against
is.
Karen Reed. We'll get a break. Get you back for more.
We want to hear Mark go off on, let's go back to the courthouse steps. I paused it at the right time. We want to hear Mark go off on the judge about how it's not normal for a district attorney who's recused himself to be sending emails on his private email server. Hold on. Got to go give Tommy and Boston Mike a like after this, please. Before we can even get back to Court TV with the ridiculous commercials. All right, here we go.
All right, I'll let you go.
Oh, no.
So
The guy. I got my phone.
He got his phone back.
It's only been a year.
I don't think it works. Got all my information. It's a step in the right direction. So.
That's a shop which I haven't seen new books.
I don't know if that's a compliment.
That is a compliment.
Yeah.
Wow. Got your phone back.
Yeah,
How's it
so
feel?
Feels good. There's a lot of information on here, like we said, that, we need to provide a defense, like accusations they're making against us. I can refute things they're saying by going through old messages, stuff like that. So I need to be able to dig through this, and I've been trying to get it back for about 14 months now, and we finally got it. So we're good.
Are we going to write the judge a letter, do you think?
Today's not the day to talk about letters. Got his phones. We're gonna get the text messages, emails, other things. So it's a long haul.
Tim, how frustrating was it to get up there in front of the judge and argue that to like deaf ears, it seemed like?
Yeah. So a lot of you guys are veterans of this courthouse, this case. Remember?
Oh, snap. I got the snap. What do you mean, snap? That's happening a lot with YouTube. They suck. StreamYard sucks. Hold on, I just got to take it back a minute to get the end of that argument. Okay, got it back on real time or whatever, wherever we were. I get Bradl with his sartorial splendor. Hang on. Barrett looking good.
So, you know, a lot of you guys are veterans of this courthouse, this case. Remember when we came here for the bail revocation and the bail review? Judge Krupp likes to put us through the paces, but he usually gives us what we want. And that's what happened today. He put me through the paces. Absolutely. I had to eat my Wheaties this morning. Glad I did. And, you know, he likes to do it. He wants to challenge you, and that's okay. That's what, you know, that's what judges do, and that's what lawyers say back. So, you know, he put us through the ringer, but we ended up walking out of here with his phone. And I don't think we would have unless we were putting the pressure on.
Free the
And
phone.
we've been putting the pressure on all this time. And like, you know, how about getting this guy in here, getting the closer in here? To have Mark on the team has been such a pleasure, you know, to take some
Nothing
of the
I can
heat
do
off
about
of
it,
me
Ashley.
and push it that way. But
Other than not play it.
you know, it's been great having Mark, and we welcome him to this team, and it's a great addition. And you know, we're not gonna give up. We're gonna keep going, and you know, Aiden's gonna keep talking the talk, and he's gonna keep defending himself, and we're gonna keep defending him, and we're not gonna let up. And you know, these are smaller battles in a bigger war.
And we ain't got no quit. These are smaller battles in a bigger war. The sound is awful. They just got Wi-Fi at the courthouse like the day before the Karen Reed trial started. So the signal's not that great around there. I got to show him some grace. And we're going to watch it anyway. So if the sound bothers you, then mute it for now.
That we're gonna win. And the next step on the 17th is get the trial date, you know, get the stuff across the street in Dedham District, and I think we're gonna be okay. So 17th, we'll be back on the 17th. We have a hearing there at 2:00 and here at 3:00. So, all right.
It's 3:30.
Yep. Thank you, everybody. Thank you guys for coming. I love you guys. Bundle up. Yeah, guys. Thank you.
No, my laptop is fairly new.
Back to work, Aiden.
It's
Now
YouTube
you're
thing,
back to
I
work.
think.
Like you had two prosecutors in the room.
Yeah, here you put us through the case.
Oh my God.
Oh, snap. All right.
Let's go back into the Massachusetts courtroom and pick it up where we left off.
You know, certainly Mr. Cosgrove is aware of our demand.
But I am not. You're asking me to compel Rule 14 discovery, and I don't have the requests submitted to me.
They were made in August of 2024, Your Honor. And that was a follow-up request, Your Honor.
So
There was a May 8th discovery deadline.
but I don't have those. We're gonna go back to those discovery motions and revisit those now?
What do you mean you don't have them? They're on your freaking computer, sir. Judge. Your Honor. Look at Mark's face. My freeze game is on point. He's like, excuse me, you don't have them? This motion to compel, Your Honor, was made, or the motion to suppress was made in September. They've had his devices for over a year. We just heard Aiden say he got his phone back. What about his other phones and the 4 other phones they seized and his iPads and his laptop? I guess one day at a time, because they never even applied for search warrants apparently on those devices, because that's what Cosgrove said today in open court. Okay, look at Mark's face. He's like, excuse me? What do you mean, where are they?
Prepared to argue those now? I mean, I'm prepared to have you talk about discovery issues, see if you can resolve them, and if there's anything that the court needs to resolve with respect to emails from the district attorney or any subordinate of his, or other kinds of discovery that there's a dispute about, I'm happy to hear you. But it seems to me in the first instance, you folks ought to talk about it and see if you can resolve it. Does that make sense?
That does make sense.
Okay. All right. Are there any other motions that I need to deal with?
Not from the defense, Your Honor.
Okay.
Oh, shaboogies. It's not a quick summary, but we will after this. If somebody in the chat.
The status of the request for the taint team, and how that will proceed with respect to the other devices if the motion to suppress is denied.
Your Honor, counsel filed the revised team proposal the last couple of days. We haven't had a chance to go over it or address it. And we would just object to any, for the record, on that point, we object to any further searches. We object to, the idea of providing us with this stuff here in open court on December 2nd.
All right, here's what I'm gonna do. I'm gonna see you before Christmas. And you folks are gonna talk about the protocols, how it will work. I'm gonna get you a decision on the motion to suppress. And if there is going to be further searches, we're gonna have to deal with that at a hearing before Christmas so that the case is moving along. You have now the disclosures of the contents of the extraction. And I can hear you on motion if you were ready for that, okay? Things that you feel like should be suppressed, but I think that's pretty quick for you to pull that kind of thing together. But at a minimum, you folks ought to be in a position to figure out a team protocol for review of other devices if they're going to be searched. And you should also discuss any outstanding discovery disputes that I need to deal with. Let's talk about a time when you folks can be back.
I'm happy to do that, Your Honor. There is another motion that I filed on the 3rd.
Sure.
Judge, suggesting that we have a hearing across the street at Bederow District Court on the Tuesday the 17th.
What time is that?
That's a 2 o'clock hearing. Judge, I'm here in this building at 9 o'clock for a motion to suppress with Judge Kearney. Could we maybe suggest, I'm trying to do my best. I work every single day up until Christmas, until I leave for Christmas holiday. But perhaps if I suggest December 17th, we're all sort of in the neighborhood, maybe an 11 o'clock call here. Would that be all right?
How about 3:30?
That's fine. That's fine with me, Your Honor.
Just give me a moment.
Yeah, sure.
Just so you know, I'm here at 9, motion to suppress across the street at 2 for Rule 17 in District Court.
And lunch down the street.
John Ross is like, why can't they live stream this? They can. They just choose not to. I'm noticing that a lot with Court TV lately. You have to watch it on their channel. They won't stream a lot of stuff anymore live on YouTube. They like to get the commercial. They like to make people subscribe to their cable service or whatever the hell it is. I get it with my cable package, so that's how I get it. They choose not to. They also did not run the Brian Camp closing arguments on their YouTube channel. It was exactly like this. It's on a delay. We had to sit through commercials. We don't even know if we got to hear the whole entire thing, but we did actually get to hear the verdict, which was fire. If you guys haven't watched the Brian Camp trial, you're really missing out. It's another example of Massachusetts gone bad, but luckily he was acquitted. Thank God, for defending his family against a home invader who broke into his house with handcuffs in his pocket and a decorative knife, intending to kill him and perhaps his girlfriend and children. So he defended himself. He killed the intruder. He was on trial for manslaughter, and he was acquitted about a week ago today.
December 17th is fine.
Okay, yes, 3:30. We have a long list, I know, on the 17th, and of course we'll panel jury in the morning. So I don't expect to be able to pitch you in the morning.
The rest of this is just scheduling. Noni, they did not even get search warrants to search the rest of the devices. All they had were seizure warrants. Cosgrove said that this morning in open court. We heard it on Zoom.
Oh, perfect. Okay, so let's say 3 o'clock. So you can finish your 2 o'clock and come across the street and we'll deal with this. I don't expect it's going to be a long hearing because I think most of these things are going to work out. But, all right.
Thank you.
Different judge every time, Tracy. I don't know why.
There's another matter that you wanted to
address it as sidebar. Yes, and again, if I could just. Sure.
Okay, they're gonna do one more thing there on the sidebar, add a sidebar, and then I'll be back later this month on the 17th. Let's talk about this with trial attorney Nicole Brenecke. Nicole, this is not a case we would cover.
Oh, do we want to hear what she has to say? Let's hear what she has to say. Everyone pray for Daniel Penny. Please put prayers up. Closing arguments today in Daniel Penny. I don't know if they're done yet. The jury may get the case today. That is a huge case out of New York City. It's not being live streamed. There's no cameras in the courtroom. Daniel Penny is a 24-year-old Marine who saved a subway car full of people from a crazy, homeless, longtime felon addict who jumped onto the train threatening to kill people. He also is on trial for manslaughter for protecting all those people on that train because the gentleman sadly died, and there's a lot of questions in that case. From a rear naked chokehold that was not really full pressure chokehold, and had K2 or synthetic marijuana in his system, and they can't even tell how much. From toxicology reports, they can't even tell how much K2 is in this guy's system. So yes, thank you, Queen Olive, for that. Let's listen to what she has to say.
On court TV, if it weren't for Karen Reed and the insanity.
Oh, he said we wouldn't even be covering this if it wasn't for Karen Reed. Hang on, take it back a second. That's all they'll let me do.
Yes, and again, if I could just. Sure.
Okay, they're gonna do one more thing there on the sidebar, add a sidebar, and then I'll be back later this month on the 17th. Let's talk about this with trial attorney Nicole Brenecke. Nicole, this is not a case we would cover on court TV if it weren't for Karen Reed and the insanity that that case has brought. And this is an extension of it. Would the Commonwealth be as aggressive in a witness intimidation case if it wasn't Karen Reed? Is this a sort of, is this part of the entire dig your heels in for whatever reason in this area of the country? Or is this just something that we're picking up because of it and it happens all the time?
That's why we have this discovery dispute that's being discussed right now in a very heated manner, because all of it seems very controversial, and all of it seems like it needs more facts and clarification. Her case resulted in a mistrial, as we know. His case, however, there's voices being raised everywhere that the prosecution has failed at finding a connection between the alleged witness intimidation and her as a defendant in her own trial. So, and now we have allegations of the DA potentially meddling with some communications which were not disclosed, some discovery that was not disclosed, and I think it all just adds to the controversy. However we interpret this based on the information that we have right now, it may change once these discovery violations are rectified and more information comes to surface.
And it does sound, at least at the end of the hearing here, that both sides agree that they can work some stuff out, and they'll be back on the 17th, and we'll continue to monitor it.
She kind of said nothing.
Reed number 2 case. That's a little bit interesting. I don't think anybody's digging their heels in for Turtleboy like they do Karen Reed, but hey, here we are, and we'll watch it. Let's get a break here. We'll come back though, and head to California for a.
All right, let's see if there's any more here that we missed.
I noticed he wasn't the same because but some
All right, I think I can't listen to that crackly sound, so we're gonna move away from that for a second, or for good actually, because we're kind of done with that. Edward Kirkpatrick says, Mark did great, but wish he had pointed out that the auto delete is prima facie evidence that Morrissey has intent and is breaking public disclosure laws. I think he kind of did. He just didn't say it in exactly the most blunt of terms that I might have used, because, you have to be respectful of the court. But I think he did kind of say we can't really trust him. So thank you for your 10. Racket fracker for the 5. The more I listen to Massachusetts court cases, the more I understand how corruption can exist in police departments. It's because the courts are corrupt. Well, there are good judges and not so good judges. There are good cops, not so good cops, just like there are good doctors, good priests, bad priests, good lawyers, bad lawyers. We can't really generalize, but I hear what you're saying. Thanks, KLM, for the 5. Court TV is airing this. Thank you. I think you're the reason I went over there. Thank you so much. And it was on delay, so we got to see the video. Marcello from Argentina. Buenos dias. This judge knows the case. I don't believe he's confused. He was the one that ruled that Turtleboy could attend the Karen Reed trial, but his speech was designed to encourage his followers to harass witnesses. That's Krupp. But last time his case was in Norfolk Superior, it was in front of Katie Rayburn. So I don't know if they have like a rotating judge that hears motions on certain days. But that's a great point. Thank you. Oh, there's a screen name, you guys. Read, and read. I'm a book. Thanks for the 5. Having a rotating judges makes it easy for them not to take accountability. Yeah, but they've got laptops, right? Don't they? Right on their bench with them. Can't they just look it up? Shouldn't they have the case already pulled up with all the filings? Hi, Vivienne. God save the Commonwealth. More like God save the common sense. Just another manic Monday. Oh, yeah, just another manic Monday. Thanks, Vivian, for the 5. Desert Quill, concerning that the judge wasn't even trying to be fair-minded, too bold in his bias. Thank you for your opinion. And the 5. Hanky Janky Fibber Pants. Oh, that's cute. Thanks for the 5. It's been correcting long before my grandfather was connected in the 30s. Got articles. Thank you. Thank you. Meant corrupt. It's been corrupt. It's been corrupt long before my grandfather was connected in the 30s. I've got articles. There's no such thing as the mafia, hanky janky fibber pants. But if there was, maybe you might know something about it. Stephanie, sorry, not trying to promote just better podcast than Phelps. I don't know if it's a podcast. I don't know if it's a YouTube channel. I have no idea what it is or was. But I support Brandy Churchwell. So I would suggest if you want to listen to a podcast that actually did research on the Karen Reed case, Brandy Churchwell's is the one to go to. 13th juror. And I think Conspiracy in Canton, is that what it's called? Will I cover the Corey Richardson trial? I don't know when that is starting, Taylor. I don't know when that is starting. I don't know what it is going to conflict with. So the answer is, I don't know. Kirsten, I repeat louder. I would rather be hated than be the hater. That's why we're with Melanie. Oh, thank you. Thank you. Oh, yes. Jedi Gem. We were talking about Criminal Minds. So my daughter's friend ran into Matthew Gray Gubler on the street the other day in Soho and said he was so nice, so kind. He's always out like interacting with people on the streets of Soho, somewhere around Spring Street. Took a picture with her and was a super nice guy. Yes, Britt, taking something under judicial advisement means that the court will just take judicial notice of it. Like it's so obvious that you don't need to prove it to me. I'm just going to take it under judicial notice, meaning I'm going to accept what you're saying as true. KLM, make sure you rewind Tom to see the Killer Bees interview after court. I had it on pause the whole time, KLM. Thanks for helping. Tracy, why does an attorney have to file a FOIA request in a case? Because you don't want to order it? Yeah, because we're already in discovery. Why would I make a FOIA request? Like, it made no sense to me. Made no sense to me either. But I'm from New York. What the hell do I know? Thank you, Moon Goddess, for gifting 5 memberships, and for all of you who were gifted, welcome. Auntie Bev swinging spectacles. I saved this for the name. Amazing, amazing screen name. This screams credulity. Says Sarah, be creative. Thank you. Laura wants to know, is Krupp afraid to be involved in Morrissey's mess? Great point. Mother Oates wants to know if I'm having Mark back on my channel to interview him about this. No, he's not allowed to talk about it. He can't come on my channel to talk about the cases that he is involved in. He can talk about the Karen Reed case, certain things about it, because certain things between this case and that case are intertwined. So the answer to that is no, he can't talk about it. Mrs. Bucket, we ain't got no quit. Love you all. Team Mel Rocks. Thank you. Thank you, Mrs. Bucket. BC Natalie, you got must have tuned in late. I'm going to do a podcast, and not a podcast. I'm going to do a show on why I think that Phelps's podcast is helpful for the defense on all 8 of the episodes that I listened to. So I've already prepped it. I prepped it yesterday. These shows take a lot of work to prep, you guys. But maybe later today or tonight we can do that. We're going to do the Sarah Boone sentencing at 1:30. So when I hit stop on here, it's going to teleport you over to the afternoon stream at 1:30, where we're going to cover the sentencing of Sarah Boone. Thank you so much, Justin, for your Cash App. I appreciate you as always. Kimmy, didn't Krupp recuse himself when Mello was there? I don't recall that. If he did, then he wouldn't have been sitting in on the case today. So this is, there's 2 different tracks of cases. There's the district court cases, which are across the street, which have different judges. Then there are the superior court cases. These are, I think, the witness intimidation cases that are in superior court, which is the same court that Judge Kearney sits in. And that's where we were today in superior. So I may have been a district court judge that recused himself. But someone in the chat will correct me if I'm wrong. Hi, Glare Invasion. Hello. I don't know what time that was. 11:30. Oh, that's just now. Hi, everyone from Glare. Thanks for coming. Kelly says Court TV wouldn't need to cover it without Karen Reed. Turtleboy wouldn't have to do what he does if Karen Reed, corrupt case, police, McAlbert, etc. haven't happened, and then repeats. Rinse and repeat. Thanks, Kelly, for your super chat. Jason, Court TV had an affect that said that Officer John O'Keefe had injuries to his torso, and that the defense said it looks like he went 10 rounds with Tyson. Paul O'Keefe said that. I remember that. I don't know. There must have been a typo in there. Had an affect, had an episode. There were never any interviews. There were never any injuries to his torso. We found that out. I think Phelps did say that he had a fractured rib, which we know was from CPR. And Carol also said we do a review of the pertinent podcast episodes. I'm going to do my show on why I think his podcast is good for the defense and fodder for the defense. And we'll obviously recap some of it for you. I'm not going to go through the whole entire thing because ain't nobody got time for that. We ain't got no quit, says Mrs. Bucket. Team Mel rocks. He did get his phone back, so at least there's that. Brennan's lack of lampron. I mean, come on, you guys. This is a tough crowd in here, snark tankers. Brennan's lack of lampron, aka RC11. Can't wait to see what Turtleboy uses off his phone to be vindicated. And Romy, hi Romy, can't wait to hear my thoughts on the podcast. I have a lot of thoughts. I have to gather them all together. Turtleboy is the one threatened, yet the court accepts the prosecution narrative as if Turtleboy is a violent threat. Well, it is so far beyond me to guess what the duck anybody over there in Norfolk County is thinking, why they're going after a man. The whole thing is like we're in the Twilight Zone and it is Groundhog Day, and here we sit forever and ever and ever and ever. Amen. That is where we are. This is insane. But again, we're going to come back on December 17th for 2 things, actually. For Turtleboy at 2:00, there's going to be a hearing in district court. I don't know if we'll be able to get any feed on that at all. We only got audio today through Zoom, and then we found out Court TV had a camera in there. But since it was on delay on their regular channel only, we watched that. So we got the video as well. We got both. Kate says the reason Court TV covered Aiden's hearing has everything to do with Julie Grant and Coffindoffer having it out for Karen and Aiden. Well, that's interesting. Although, Matt Johnson was in the Karen Reed courtroom every day for the trial, and he seems to be pro Karen Reed. I don't know so much about Ted Rollins. I don't know. I don't know so much about him. I know that Julie Grant hates Karen Reed, and Big Case Mike hates Karen Reed. He said, I hate Karen Reed. I really hate Karen Reed. I really hate that woman, and I hope she goes to jail forever and ever and ever. And that whole Big Case Mike thing was just a mess. So on December 17th at 2:00, there's going to be a hearing for Aidan Kearney in district court across the street. Those are the Lindsay Gattani case, the witness intimidation case for the witness who wasn't a witness until he served her with a grand jury subpoena for a grand jury that had already been concluded, and then was text messaging furiously with Ken Mello, the special ADA, Kate Peter, the not so confidential informant, and Lindsay Gattani, the quote victim / witness, on the evening when they conspired to lure Aidan Kearney to Lindsay Gattani's house and then have him violate the terms of his bail, which threw him in jail for 60 days. They wanted 90 days, but they only got 60 days. So there's that. Oh, Ernie, so much for presumed innocence. There is no such thing, apparently, in this country. We're supposed to all be innocent until proven guilty, but there is so much hatred on Twitter for Karen Reed. It is insane. It is, everyone has convicted her. Like, not just everyone, not just like all the friends that are friends with Jen McCabe and Brian Albert, but people like Jennifer Coffendorfer who hate tweets at least once a day how much she hates Karen Reed. It's insane. It is insane. Thank you, Andrea, for your Cash App. She says, gee, Officer Kropke, Krupp you. Isn't that great? Oh my gosh. Andrea coming in hot with the West Side Story. Cash App, thank you. Appreciate you so much. And I always love a good musical reference. So there's that. Lindsay was there today. It says, who, if anyone, was driving the ambulance or ambulance driver? We saw her come out of court with her escort. She had an officer escort. Thank you for that and for your super chat. So there's that. Move to Blue Sky. I don't want any of it. I don't want any of it. None of it. All right. When I hit end on this stream, it will teleport you to the 1:30 Sarah Boone sentencing hearing. So smash the notification bell on that so that you can come back and watch that with me, because that's going to be fun. Remember, it was a good day. It was a good day in Sarah Boone world. It was a good day until she decided to play hide and seek with George after they were puzzled out and arts and crafted out. And then she zipped him in the suitcase, made a video of it, taunting him in the suitcase, then went upstairs and went to sleep. And when she came downstairs in the morning to go out for a cigarette, she found him dead in that suitcase, and she was guilty. I mean, she was found guilty. And today they're going to put some Dr. Pepper emojis in the chat. I don't know if she'll get a Dr. Pepper in court today, but please. Yeah, break out all of the Boone emojis. Boone's Farm, Strawberry Hill. We've got Dr. Pepper. We've got a suitcase. I forget what other ones we have, but we've got them all. It's going to be crazy. It's going to be crazy. We'll see. We should hear from a couple of victims. And R.I.P. George. All right, my friends, stay cool, stay kind, stay classy. Thank the moderators for being here, because without them, I could never, ever do this, because this is a whack case to cover because of all of the hatred that is out there. But you guys are better than that. I know you are, because not only are you cool, but you're kind and you're classy, and you're going to stay that way. You know why? Because it's not hard. It is really not hard to rise above, lift up other people instead of dragging them down. Don't be like them. We play whack-a-troll over here, and we're really, really good at it. All right, you guys, I'm going to teleport you over there. Safe travels. Buckle up, buttercups, and I'll see you at 1:30 Eastern. Peace.